On July 9th, President Trump nominated Judge Brett Kavanaugh to the Supreme Court to replace retired Supreme Court Justice Anthony Kennedy. If confirmed, he would be the president's second nominee to take a seat on this nation's highest court. Born here in Washington, D.C. in 1965, Judge Kavanaugh attended Yale Law School, clerked for Justice Kennedy, and played a key role in helping identify President George W. Bush's judicial nominees. Now we're going to hear from the nominees in his own words at his earlier confirmation hearings and more recently at two conservative think tanks here in Washington. Later, we'll hear from those who know him best, legal scholars, former law clerks, old friends, and his pastor. First up, his confirmation hearings in 2004 and in 2006 for his current position on the U.S. Court of Appeals for the District of Columbia Circuit. President George W. Bush first nominated Judge Kavanaugh to the D.C. Circuit job in 2003. He wasn't confirmed, however, until 2006.
Just one final question. Could you please speak about the significance of judicial temperament and indicate what aspects of judicial temperament you consider to be the most important?
Well, I think it's critically important, Mr. Chairman, for any judge to exhibit the proper temperament on and off the bench at all times. And what that means is in dealings with one's colleagues on the bench, having an open mind, being respectful of a colleague's views, both at oral argument and in writing opinions. I think it means being respectful of the lawyers who come before the court and not treating them disrespectfully, but to have proper respect for the lawyers in the court. And it means having a proper respect for the law and a humility, understanding that you're just one judge on a panel. There's a reason you wear a black robe. It's because you lose your individual preferences, your individuality when you take a seat on the bench. The black robe signifies that you're part of a judicial system and you're there to interpret the law fairly. So I think that's all encompassed within judicial temperament, and it's something I've seen firsthand with Justice Kennedy and Judge Stapleton, Judge Kaczynski, and it's something that I, were I to be confirmed, would always remember my proper place in the system.
One last question. Would you please explain to the committee why you want to be a federal judge?
I've always had, Mr. Chairman, a commitment to public service since I was young. Since I got out of law school, I've always thought that being a judge was the highest form of public service that a lawyer could render because it helps maintain our constitutional system, which has been in place for over 2 centuries and helps protect the rights and liberties of the people. What courts do every day, and I think Senator Schumer alluded to this, is not always apparent to the people. But it's critically important, and there's much of what Senator Schumer said about that I agree wholeheartedly with, about how important it is. And so in terms of commitment to public service, a commitment to our constitutional form of government, and a commitment to protecting rights and liberties of the people, that's why I think I would want to be a judge.
The question is secrecy in government, and this administration has shown more secrecy than any administration I've served with, from the Ford administration forward. You were the author of one of the first indicators of this increase in secrecy, Executive Order 13233, that drastically changed the Presidential Records Act. It gave former presidents, their representatives, and even the incumbent president virtual veto power over what records of theirs would be released, posed a higher burden on researchers petitioning for access to what had been releasable papers in the past. After the order was issued, a number of historians, public interest organizations opposed the change. The Republican-led House Committee on Government Reform approved a bill to reverse this. A lawsuit to overturn it was filed by Public Citizen, American Historical Association, Organization American Historians, and a number of others. Why did you favor an increase in the secrecy of presidential records?
Senator, with respect to President Bush's executive order, I think I want to clarify how you described it. It was an order that merely set forth the procedures for assertion of privilege by a former president. And let me explain what that means. The Supreme Court of the United States in Nixon versus GSA in 1977, opinion by Justice Brennan, had concluded that a former president still maintains a privilege over his records even after he leaves office. This was somewhat unusual because there was an argument in the case that those are government records, but the court concluded that both the current president and the former president have the right to assert privilege to prevent the release of presidential records. That's obviously a complicated situation. The issue was coming to a head for the first time because there's a 12-year period of repose. So 12 years after President Reagan left office was when this President Bush came into office, and there was a need to establish procedures. How's this going to work? Two different presidents asserting privilege or having the right to review. No one really had a good idea how this was going to work. The goal of the order was merely to set forth procedures. It specifically says in Section 9 of the order that it's not designed in any way to suggest whether a former president or current president should or should not assert privilege over his records. You're quite right, Senator Leahy, that there was initial concern by historians about the order. I like to think it was based on a misunderstanding, and Judge Gonzalez and I undertook to meet every 6 months or so with a large group of historians to discuss the order and explain it, and then after that to discuss any problems they were having with the order and to help improve it if they suggested ways for improvement. I think those meetings, I think the historians who've come to see us have found them useful, and I think we helped to explain what we had in mind and what the President's order meant in terms of the procedures. So that's my explanation of that order.
As I understand the role of the committee and the advice and consent role of the Constitution, under the Constitution, it's to explore qualifications and judicial philosophy. That is, whether you are willing to subjugate any personal views that you may have, whether they be political, ideological, or otherwise, to what the law is, and to faithfully enforce the law as written by the Congress or as determined by precedents of the United States Supreme Court. Do you have a similar understanding of what the role is of judge and how that is different from any personal opinions, philosophical or ideological or others that you may have?
Well, I think, Senator, the founders established an independent judiciary and discussed it in Federalist Papers because they wanted people who would be independent of the legislative and executive branches to decide cases fairly and impartially without regard to their personal preferences. There was discussion at the time, I think Federalist 81 discusses making the judiciary an extension of the legislature or somehow having review by the legislature, but there was a decision made to have an independent judiciary, and that's the foundation of our system of rule of law. The founders also recognized, I think necessarily and certainly at the time, that people with government service who had served in the legislative branch or served in the executive branch would become judges. Chief Justice Marshall, for example, would have backgrounds involved in government service or political service, but they also had confidence in the ability of people in our system, once they became judges and put on the black robes, to decide cases fairly and impartially. And that's the way the systems work for more than 2 centuries. And I know there's been some discussion about that, but that's the way the systems worked in terms of deciding cases fairly and impartially and not based on political or personal views.
In your opinion, did Justice Kennedy, in your experience, was he able to make the transition from lawyer to judge and make that sort of transition you described?
Justice Kennedy always decided cases fairly and impartially and taught a lot to his law clerks about how to do the same.
And in my introductory comments, I pointed out there that you're not the only person to come before the court who has represented a client in the arena. For example, Justice Ruth Bader Ginsburg. In your opinion, has she been able to successfully distinguish between her role as General Counsel for the American Civil Liberties Union and her role as a judge?
And my observation, yes, she's an excellent justice on the Supreme Court. It's not for me to be commenting too much on Supreme Court justices, but I think she obviously decides cases fairly and impartially, and was a judge on the D.C. Circuit before that who was widely respected, as she is on the Supreme Court.
Well, and Justice Breyer, who was the Democrats' chief counsel on the Senate Judiciary Committee. Do you think he's been able to successfully make the change between that job and the role as judge, a circuit judge first, and then now as a member of the United States Supreme Court?
Yes.
Attacking the Clinton administration's assertions of various privileges during your work in the Office of Independent Counsel, and on the other hand, helping to draft Executive Order 13233, which establishes policies and procedures to govern the processing of requests for presidential records and the assertion of constitutionally based privileges. Does this executive order set forth those circumstances under which an assertion of executive privilege should be made and or would be successful? And does anything in the executive order purport to block prosecutors or grand juries from gaining access to presidential records in a criminal investigation?
Senator, nothing in the order purports to assert a privilege at all. It's up to the individual president, former president or current president, to assert a privilege following the procedures in the order. So nothing blocks anything from a criminal or grand jury investigator. And again, there have been some misimpressions about the order when it first came out. Some historians were concerned, and we took proactive steps. Judge Gonzalez and I met with historians to try to allay their concerns, explain the order. We met with people on the Hill also who had questions about it. And I think over time, I think we've explained what the order was designed to do, which is merely to set up procedures.
And with regard to the criminal aspect, does it block prosecutors or grand juries from gaining access to presidential records in a criminal proceeding?
It does not block any access.
And your arguments on behalf of the Office of Independent Counsel regarding privilege was that government attorneys in the Clinton administration could not invoke the attorney-client privilege to block the production of information relevant to a federal criminal investigation, right?
The court ruled that the government could not assert a privilege to block it from a criminal investigation under Nixon. It said that it would, yes, that's correct.
So I don't understand where the inconsistency is here. I know some of my colleagues may have tried to assert it, but I don't see it. And correct me if I'm wrong, if I'm missing something here. But the key issue is the assertion of privileges in the context of federal criminal investigations. In fact, you referred to your Georgetown Law article in 1998, which was authored during the Clinton administration, and didn't you there specifically recognize the difference between asserting executive privilege in the criminal context versus outside of the criminal context?
I did recognize the difference in that article. That was a difference that had been also recognized in the cases.
And isn't it further the case that you actually acknowledged or argued a presumptive privilege for presidential communications? And I have a quotation here that was supplied to me by the staff, and that, quote, "it may well be absolute in civil, congressional, and FOIA proceedings."
That's correct. That's from my Georgetown article.
And entirely consistent with this statement, doesn't the executive order that I referred to specifically recognize that there are situations where a party seeking access to presidential records may overcome the assertion of constitutionally based privileges?
Yes.
So, okay, a few more points here. During your service as Associate White House Counsel, have you ever worked on a matter where the President invoked or threatened to invoke executive privilege in a criminal context?
Senator, I'd like to answer that question, but I don't think it's my place to talk about internal discussions of privilege claims. I just want to be careful not to go down a road.
All right. Well, let me ask you
There's been no public assertion. I just don't want to go down that road.
I appreciate your desire to treat that with confidentiality. Did you work on the Bush administration's assertion of executive privilege to shield the records regarding the pardons issued by Bill Clinton at the end of his presidency and to withhold from Congress Justice Department documents related to the investigation of alleged campaign fundraising abuses by the Clinton administration?
I was involved in that matter, working for Judge Gonzalez, who in turn was providing advice to the president.
I do believe that the founders thought that the posture of the government with regard to religious expression should be one of neutrality, not hostility. I realize as a lower court judge you're going to be bound by the Supreme Court's precedents, but I wonder if you would address the issue of religious liberty and religious speech insofar as how you believe in your position as a circuit court judge, how you would approach those issues.
Senator, if I were confirmed to be a D.C. Circuit Judge, I would, of course, follow the precedent of the Santa Fe case. That case addressed a question that had been left open in the Lee versus Weissman case in 1992. In that case, there was a school-sponsored prayer at a graduation ceremony where the government was actually involved, and one of the questions that was left open was what happens if a student or a private speaker participates in a school event as a private speaker. And in the Santa Fe case, I think the court concluded, based on the facts and circumstances of the case, that it could be attributed to the school and so was a violation of the Establishment Clause. I think the overall area represents a tension the Supreme Court has attempted to resolve throughout the years in terms of facilitating the free exercise of religion without crossing the Establishment Clause lines that the court has set out for many years now. I know that the court in recent years has made clear in a number of cases that private religious speech, religious people, religious organizations cannot be or should not be discriminated against, and that treating religious speech, religious people, religious organizations equally, in other words, on a level playing field with non-religious organizations, is not a violation of the Establishment Clause. In past years, there had been some suggestion that treating religious organizations the same way in the public square as non-religious organizations could sometimes be a violation of the Establishment Clause. I think the court's really going to a principle of equality of treatment does not ordinarily violate the Establishment Clause. Again, equality of treatment of religious speech, religious people, religious organizations, equality in the public square. And that's been something we've seen over the last, I'd say, decade or a little more. At the Santa Fe case, again, the issue there was that although it was a private speaker, the court found, based on all the facts and circumstances, that it was attributed to the school and therefore fell within the prohibition in Lee versus Weissman.
Do you have a view that's established as a living document, as a strict constructionist of the Constitution itself?
Senator, I believe very much in interpreting text as it's written and not seeking to impose one's own personal policy preferences into the text of the document. I believe very much in judicial restraint, recognizing the primary policy-making role of the legislative branch in our constitutional democracy. I believe very much as a prospective inferior court judge, were I to be confirmed, in following the Supreme Court precedent strictly and absolutely once as a lower court judge. I think that's very important for the stability of our three-level system for lower courts to faithfully follow Supreme Court precedent, and so that's something that I think is very important. In terms of the independence of the judiciary, I think that's something that's the hallmark of our judiciary, the hallmark of our system, that judges are independent from the legislative branch and independent from the executive branch. I think that's central to my understanding of the proper judicial role. So in terms of text, precedent, restraint, independence, those are the kinds of principles that I think would inform my approach to judicial decision-making were I to be confirmed.
Do you have a viewpoint on issues, say, as marriage and the determination and the definition of that? Is that something that the courts should establish, or is it left to the legislative bodies?
Well, Senator, that's the kind of question that, were I to be confirmed, could come before me, so I'd hesitate to talk about the specific issue. In terms of your general principle about judicial activism, I do think that some of the worst moments in the Supreme Court's history have been moments of judicial activism, like the Dred Scott case, like the Lochner case, where the court went outside its proper bounds, in my judgment, in interpreting clauses of the Constitution to impose its own policy views and to supplant the proper role of the legislative branch. So I think in terms of judicial activism, that is something that all judges have to guard against. That is something that the Supreme Court has to guard against. And throughout our history, we've seen that some of the worst moments in the Supreme Court history have been moments of judicial activism where courts have imposed their own policy preferences.
Thank you.
After a decade on the bench at the D.C. Circuit Court of Appeals, Judge Kavanaugh was asked by the American Enterprise Institute to speak on the intersection between American politics and the Supreme Court. Here's the judge talking about his approach to interpreting the Constitution, the power balance between the executive and judicial branches, and the Second Amendment.
As to when the Supreme Court justices should, let's say, overrule stare decisis, and it seems to me that liberal judges have no qualms about doing so when it suits their purposes, but that may be just my biases on this. Is there a criterion which one could use as to when the court should overturn a decision which at least the majority feels is incorrectly been decided?
Right. So I think justices of all stripes agree that stare decisis is important but not an inexorable command. It's not inflexible. It's not absolute. And if it were, well, you would have some horrible decisions still on the books, Plessy versus Ferguson overruled in Brown v. Board, and many others. So the court, it is appropriate that the court overrule precedent in certain circumstances. It's also appropriate, in my view, and the court has said many times, that stare decisis be the starting point. You can't reinvent the wheel necessarily every time you confront an issue. The question then is, and the hard question is, when is it appropriate and when is it not? And I would love to have a perfect answer to that question. To my point on the first question, setting the rules of the road in advance, which is a general thing I think about in everything related to jurisprudence, I think it's really hard to have a set formula for overruling that's going to work in all cases. And to speak in common parlance, when it's really wrong and has really significant practical effects, and there hasn't been reliance interests of the kind you would have with a property or contract decision, that seems to be a descriptive of when the court will overrule something. But is that a formula that binds? Is that a formula that tells you in advance with justices of different stripes when to do it and when to not? Not really. I just think that's when it happens. Really wrong and really significant from the viewpoint of the justice, practical significance, and not a case where there's specific reliance interests. I would love to have a formula. You know, to go to idealism versus realism, one of my goals, which is probably unachievable but doesn't mean I shouldn't strive for it and seek to have all of us strive for it, is that judges from a variety of philosophical and policy viewpoints could agree on jurisprudential methodology. And we do on large numbers of cases, but then there are some where obviously we don't. And stare decisis is an issue where there is a formula, but it's not one that I think gives much predictability or guidance to particular judges or that binds in a way. And so it leads to the criticism that you articulated. I think you could go to a different crowd across town and find the exact same critique in reverse, because everyone thinks the other people are doing it in a less principled way than they're doing it. So that's one of the problems with the stare decisis doctrine. I'm not sure it's solvable, but I'm going to keep trying.
Can you think of a case that deserves to be overturned?
Yes.
Would you volunteer one?
No.
Pending confirmation hearings. Yes, sir, right here.
Thank you very much.
Actually, I'm going to say one. Morrison v. Olson.
That's the independent counsel statute case.
It's been effectively overruled, but I would put the final nail in.
Hear, hear. You're a student of the separation of powers, and I would make a normative statement here and see if you agree that when the courts do not adequately police the executive agencies when they're interpreting statutes, it can corrupt Congress and the executive. Congress in the sense that it causes them to say, we're going to write even vaguer statutes and punt to the executive, which we can then blame if we don't like the rules they write. And the executive, because the executive then says, all right, we have free rein to write the regulations we want as we want them or as the president wants them. Mm-hmm. You agree with that?
I think it's hard to generalize about the effects on Congress on all of this, because Congress is 535 people and there are different statutes in different areas where they do this. I think what happens oftentimes in Congress is there is disagreement about something and they can't resolve it, and the compromise sometimes is to punt the issue to the agency. And if they do that through broad, capacious terms, our job is not to interfere with that decision. Sometimes, however, the compromise in Congress is to draw a line, maybe an in-between the line between the two positions, and then the agency wants to go beyond the compromise. And that's where the court's role is to step in, I believe, and police that line for to protect the Congress and to perform our role in the separation of powers. I want to make clear, it's a balance always for the courts. We can't be unduly interfering with the proper operation of Congress and the executive branch, but at the same time, what I think has happened is perhaps undue abdication in some of these agency cases. But there are cases, I just want to emphasize, where it is appropriate to allow an agency room to make policy decisions because the statute gives them that room to make the policy decision.
You've really focused on it. Has become a hot issue of debate in recent years, and that is judicial analysis of executive regulations, executive branch agency regulations, and interpretation, implementation of statutes. Your opinion in a dissent in the Coalition of Responsible Regulation versus EPA, you wrote the following. To be sure, courts must be wary of undue interference with an agency's actions, implementing its statutory responsibilities. But undue deference or abdication to an agency carries its own systemic costs. If a court mistakenly allows an agency's transgression of statutory limits, then we greenlight a significant shift of power from the legislative branch to the executive branch. So, pungent words. Have courts been too deferential, in your view, to the executive branch in assessing regulations in recent years?
In a word, yes. I think courts have been too deferential, and it really stems from expansion, I would say, of the Chevron doctrine, which is the idea that when the statute is ambiguous, the court will defer to the executive branch's reasonable interpretation of the statute. And I think courts have been a bit too quick to find statutes ambiguous, to go back to the point I made earlier about the debate about how ambiguous must the statute be in order to trigger Chevron deference. And I think courts have not done a good enough job in enough cases of sticking with the words of the statute that Congress passed. Chevron itself has an important footnote, footnote 9, that to really get in the weeds, it often gets overlooked, about courts are supposed to apply all the tools of construction to the statute and figure out the best meaning of it before they engage in the step of deferring to the agency. And sometimes that exercise gets overlooked, I think, by courts, or doesn't get sufficient attention. The bottom line is, when Congress passes a statute and sets the boundaries, it's our job, I believe, as courts, to make sure that we police those boundaries in a case, justiciable case, when someone has standing. So when we don't do that, what we're allowing the executive branch to do, and this is a bipartisan issue. This is not a partisan issue. Republican administrations and Democratic administrations push the envelope with their agencies. Our job is to hold fast to the line that Congress has drawn and make sure that we police it. Again, not undue cramping of the executive branch, but try to figure out what the line that Congress drew, and then hold fast to it. I should say the reason executive branch agencies do this is, of course, because presidents run for office on policy agendas. They don't run through New Hampshire and Iowa and Wisconsin and all the states and say, when I get into office, I'm going to make sure that the agencies all carefully hew to the law. That's not a platform. You're running for office on health care and immigration reform and on economic issues. And when you get into environmental protection, when you get into office, you want to get either new legislation passed, or if you can't get new legislation passed, get the agencies to exercise their rulemaking authority to achieve your policy objectives to the extent permissible. And that to the extent permissible becomes really the battleground. And so the agencies have a tendency, and it's understandable, to push the envelope, And Chevron really encourages that, because an agency might say, well, can we get away with this? Is it really legal? And well, it's ambiguous. Okay, let's go for it. That kind of rationale. And that's where I think the courts really have to step in. Again, a bipartisan issue. I don't think this is a partisan issue at all. The court's job is to hold true to the line that Congress set forth.
Chevron, 1984 precedent, Chevron versus NRDC. You mentioned the two-part test. How ambiguous is the statute?
Yes.
And then how reasonable is the interpretation by the agency if it is ambiguous?
Yes.
And then the tendency has been, if it seems reasonable, then the agency gets its way. Is it time to revisit Chevron?
Well,
and if not overturn it,
right,
in whole, at least rein it in and put some barriers on it?
Well, I think it should be reined in. Part of it is just applying that. Again, I hate to cite a footnote, but footnotes are where all the important things are sometimes buried in Supreme Court opinions. Footnote 9 of Chevron, faithfully applied, does rein it in a significant degree in and of itself. And significantly, I think the Supreme Court has expressed skepticism about Chevron in recent years. Under what circumstances does it apply? Interestingly, in the King versus Burwell case last year, Chief Justice Roberts' majority opinion, in the course of saying that the statutory interpretation was permissible, did go out of his way, and this is a six-justice opinion, to say that Chevron was inapplicable in cases of great significance. I'm paraphrasing there, but major questions kind of cases. And that leads to the question, well, this doctrine that we've had for so long is inapplicable in the really important cases. What kind of doctrine, why is it now applicable in the less important but still important cases? And I think we're going to have two problems as lower courts. One is, what's the line between those major cases and the less major cases that are still significant, and when Chevron applies? And then I guess this will be above our pay grade and for the Supreme Court to consider, but if they've drawn this exception and they've drawn some other exceptions to Chevron, what's the state of the doctrine in general as an analytical whole at this point?
Well, I noticed that in King v. Burwell as well, but I also detected, even in Justice Scalia's opinion in the utility group versus EPA opinion, not an explicit rejection of Chevron, but a kind of walked around it rather notably. And he has been one of those had been one of those of the Supreme Court who'd been most frequently cited Chevron in some of his own opinions.
So I think a doctrine like this, and it makes sense when Congress uses words like reasonable and appropriate and feasible and practicable, those kinds of words in a statute that are often in statutes. We want to give Congress wants to give agencies room to make decisions. But when Congress sets forth a specifically worded statute, then courts' job is to enforce that statute as written. I think what Justice Scalia observed, I don't want to speak for him necessarily, but I think what the opinions reflect is over time, the phenomenon I described, which is agencies pushing the envelope more and more, became apparent to judges, and I think caused some discomfort. And what that leads to is things like King versus Burwell of the court saying, well, we're just not going to apply Chevron in this case. Okay. There you have it. It's not going to apply because they're not comfortable in a really significant case saying we're just going to defer to an executive branch's agency's interpretation.
All right, another area involving the Bill of Rights, free speech. Your opinion in Emily's List versus the Federal Election Commission struck down federal limits on the amount of money that nonprofits can spend on campaign speech. This would suggest to me that you have some sympathy for the Supreme Court's jurisprudence on campaign spending and speech, such as Citizens United. Is that a fair inference?
Our job in the Emily's List case, I thought, was to apply the Supreme Court precedent as it existed. Do I agree with the whole edifice? If we started back in 1976 with Buckley versus Vallejo, I don't know where I'd even begin to analyze that question. But I think the court itself, and certainly my job and Emily's list, was to figure out where the court's jurisprudence led on a question like that. And the question, it seemed to me that the court's jurisprudence led to the idea, which our court subsequently confirmed in the Speech Now case and in-bank case, was that outside groups have an ability to express their views about issues of the day and in support and opposition to candidates. And to express your views, you have to raise money to do that. And that, of course, is what our court held unanimously in bank in the wake of Citizens United in the Speech Now case. Now, Emily's list was before Citizens United, so I was analyzing even the case law before Citizens United to reach that conclusion, but I thought that's where the court's jurisprudence led us. I'll say one thing about the campaign finance jurisprudence is there's clearly a structure that has been set up as a result of the jurisprudence where the political parties and candidates can't raise large sums of money and outside groups can. And particularly with I don't envision the court going back on the candidates part of that in the near future. But on the parties question, the parties have much less power to raise money now than outside groups. And this is really since 2003, not a surprise that outside groups therefore have a much more prominent role in our political system today than they did when parties could raise a lot of money. Now, you can say it's good or bad that the parties have less power vis-a-vis the outside groups, but that is a reality, I think, and it's a reality directly attributable to the Supreme Court's jurisprudence, which has maintained the limit on contributions to parties, but has not allowed limits on contributions to outside entities. And I guess different groups of justices would resolve that disparity in different ways. Some would eliminate the caps on contributions to parties. There was a case that went up there from our court where the court summarily affirmed the existing jurisprudence 6-3, and it was Justice Kennedy, Justice Scalia, and Justice Thomas who dissented in just a short order from the decision not to take that case up on the merits. That was really, should we now allow the parties to raise the money again, overrule that part of McConnell. As of now, the jurisprudence seems stable for the moment, at least through this election, stable in the sense of outside groups can raise unlimited amounts, parties cannot.
But do you agree with the trend of the Supreme Court's jurisprudence that money spent during campaigns does represent speech and therefore deserves First Amendment protection, or at least strict scrutiny of any limits on that spending?
Absolutely. Yeah, that's what the Supreme Court has said, and certainly I said pretty emphatically in the Emily's List opinion. I think political speech is at the core of the First Amendment, and to make your voice heard, you need to raise money to be able to communicate to others in any kind of effective way. And so I think that's lies at the core of the First Amendment.
Okay, thank you. Now, a related issue that has been much debated in this administration in particular is the suspension of the laws. That is, the president's decision not to enforce either certain laws or parts of laws. Two examples: the marijuana provision of the Controlled Substances Act related to Colorado and Washington, which passed referenda legalizing marijuana, and of course the immigration statutes and the deportation elements of immigration law. How much leeway does a president have, in your view, to not enforce statutes?
Right. So I want to distinguish two categories here. There are statutes that regulate the executive branch: Freedom of Information Act, Anti-Torture Act, acts that regulate executive branch officials and how they conduct their business. On those statutes, the executive branch has a duty to follow the statute unless the statute is unconstitutional, in which case the president can state a constitutional objection and someone with standing can bring the case to court. And the courts won't have the final word on that case, whether the president's right or Congress is right about whether that statute regulating the executive branch is unconstitutional. But absent a claim of unconstitutionality, the separation of powers, as I understand it, requires the executive branch to follow that statute. There's a separate category, body of laws. the primary body of laws that regulate private behavior, that prohibit drug possession or drug distribution. Those kinds of prohibit bank robbery, prohibit certain kinds of dumping of illegal substances into streams or waters. Those kinds of federal laws that are ubiquitous, that regulate private behavior. And the question is, to what extent can the president or the executive branch say, we're not going to enforce a certain category of those laws because of policy disagreement, because of resource constraints, because of constitutional objections. And I don't mean to punt unduly, but I tell my students every year in separation of powers for the last several years, I think that's one of the great unanswered questions of constitutional law. And why is it an unanswered question? Oftentimes it's difficult for someone to have standing. Okay, I'm not going to enforce the certain kinds of drug laws. Well, who has standing to challenge the president's or the executive branch's decision not to do that? That's a difficult inquiry in many cases as well. So it doesn't, it's a hard question to answer. One of the things to think about, because I've written different things about this, kind of tiptoeing around different parts of this, the pardon power. So how does that relate to prosecutorial discretion? Today, the president has the raw constitutional power to pardon every federal offender. The raw power. It is right there in the text of the Constitution. And if that's true, and it is true, to what extent is the president, the executive branch, required at the front end to bring charges against someone in categories of cases where the president thinks, well, I think they should be pardoned. I don't think these laws should be enforced. So Akil Lamar, the professor at Yale Law School, brilliant scholar, has written, and I've found this worthy of attention, what's the relationship between prosecutorial discretion and the pardon power? And I think that's a tough question as well. So I think it's unanswered. I think it's difficult. Certainly, resource constraints are a traditional justification for prosecutorial discretion. Okay, we have a limited bank of resources here, so we're going to focus on serious drug crime, serious economic fraud. We're not going to focus on certain kinds of cases, and that traditionally has been a justification. The theoretical question, but maybe also a real question, is what about when you have plenty of resources? So that's not a justification, but the executive branch says, we just don't think it's appropriate to be penalizing people for a certain kind of behavior that is illegal under the statute that Congress has passed. That is a very challenging question. Again, remember the pardon power, though. So there is the raw pardon power at the back end to say, we're going to pardon everyone who's been convicted of a certain class of offenses. But
the suspension of the laws in this administration, Congress has found itself frustrated in checking that when it has objected. And part of the problem is the issue you raised of standing.
Right.
Because you have to have an injured party, and the Supreme Court tends to take and certainly under Justice Roberts, a pretty tight definition of standing. So, for example, in the case involving the marijuana laws, we had a case that was the states of Oklahoma and Nebraska appealed to the Supreme Court to say, would you take, we've been injured by the fact that Colorado is not enforcing the marijuana laws, so it's spilling over into our territory. We have to expend law enforcement resources to deal with drug gangs and so on. And they appealed to the Supreme Court, and the Supreme Court did not take the case, though Justice Thomas issued with Justice Alito concurring, a rather pointed dissent saying they should also take it. Now, if I look at your cases on standing, you have suggested that the Supreme Court should look at perhaps broadening, and correct me if I'm putting words in your mouth, broadening its definition of standing in a way that when you have a clear injury, take the case, or they have a right to their day in court.
Yeah, that was in one pocket of standing jurisprudence, so-called zone of interest standing, and the Supreme Court subsequently, I think, did narrow the restraints that it had imposed on standing based on zone of interest standing. More broadly, I think standing jurisprudence is, I haven't suggested more generally expanding standing beyond what the Supreme Court has said. But I think it can be difficult to apply to particular cases. Who is an injured party in a particular case? What kinds of injury are good enough to make it a case or controversy for purposes of Article 3 of the Constitution and to bring it into court? I think that's that's historically been a very difficult area of Supreme Court jurisprudence. And to what extent do states have standing? That, of course, was an issue during the Bush administration in the Massachusetts versus EPA case, where the court ultimately found that the state of Massachusetts did have standing in a case involving global warming. To what extent do states have standing more generally to challenge effects of decisions made by the executive branch that have impact on state citizens or on the states as sovereign? That's a pretty challenging area of Supreme Court jurisprudence right now. We may get more guidance in the near future or may not. These things tend to be dialogues over years rather than resolved for all time in one sitting by the Supreme Court. So we will see how that transpires.
This is a debate over, sometimes even among conservatives, over the gun cases in the Second Amendment. McDonald, as you know, it was the case which incorporated the Heller decision to the states. And Justice Alito used substantive due process under the 14th Amendment in his 5-4 majority opinion. But Justice Thomas wrote that he would have used the Privileges or Immunities Clause of the 14th Amendment, which in an oral argument, Justice Scalia had dismissed as the darling of the professoriate as an analysis.
I don't think he meant that as a compliment.
He did not mean it as a compliment, though. And at the Journal, we have people on both sides of that question. So, what's your view about whether? And as you know, the relevance of this is that there are some libertarians, right, who want to revive the Privileges and Immunities Clause as a way to, which has basically been considered by many scholars a dead letter since the slaughterhouse cases of 1873, I think. But they want to revive it as a way to protect individual liberty under the Constitution. Where do you come down on this?
So the case in question concerned incorporation of the original Second Amendment against the states. And with many of the constitutional amendments in the Bill of Rights, of course, the Supreme Court over time, under the guise of the 14th Amendment, had decided, okay, yes, the First Amendment protection for freedom of speech applies not just against the federal government, but against the state governments. Sixth Amendment right to counsel not just applies in federal cases, but also in state cases. The 14th Amendment, whether it's through substantive due process or through the Privileges and Immunities Clause, really analytically in the end doesn't matter which home it has, but the court over time had incorporated all of these rights against the state governments. The Second Amendment, that had not happened yet until the McDonald case. And the question really was, are we going to treat the Second Amendment like these other amendments in the Bill of Rights that have been incorporated against the state governments? And the court concluded, yes, we are, because there's no reason really to distinguish the Second Amendment from the other amendments on that basis. On the question of unenumerated rights generally, I think one of the important things for judges to do is to enforce the rights that are in the Constitution. And we're not supposed to just abdicate and let Congress and the president interpret them. That comes from Marbury versus Madison. Interpret them by themselves without any judicial role in cases or controversies. We enforce the words and the rights that are in the Constitution. What about rights that are important, we think, but aren't in the Constitution, explicitly at least? And the court has struggled with that. The test that usually gets bandied about, whether you call it privileges and immunities or substantive due process, is a test. Well, the court will recognize unenumerated rights that are deeply rooted in the nation's history and tradition. A case called Glucksberg articulated that test. Now, how do you apply that to particular rights? At what level of generality do you define the right to figure out whether something's rooted in history and tradition? That's been the battleground in the unenumerated rights cases. I don't think, whether it's substantive due process or privileges and immunities, there's some new font for courts to go around, font of authority for courts to go around and create a bunch of new rights that we think ourselves are important. I think we need to stick to what the Supreme Court has articulated as the test for unenumerated rights, which is deeply rooted in history and tradition. Otherwise, courts really will become politicians or political policy-making bodies. Oh, this right's important to me. I'm going to find it in the 14th Amendment. Well, there's certain other rights important to you. You're going to find it in the 14th Amendment. This is, Judge Bork, of course, railed against that kind of judicial creation of unenumerated rights willy-nilly. And that's something that I think the Supreme Court itself has largely respected. Certainly the test it applies, deeply rooted in history and tradition, is a test that respects or envisions a narrow judicial role. And I think a narrow judicial role is appropriate in that kind of case.
But there has been criticism for finding a right, the gun right, for individuals in the Second Amendment after 200 years of the court not having discovered that right in Heller. J. Harvey Wilkinson, Richard Posner, and others have suggested that that was in fact an example of activist conservative judging and finding exactly the sort of enumerated right that conservatives like. And that's not what Judge Bork or others might have done.
Well, the difference is between unenumerated rights and enumerated rights. And the right to possess arms, keep and bear arms, is right there.
But the liberal justices in Heller said, actually, it says those rights are for a militia.
Well,
not for individuals.
Right. And that required analysis of the text and the prefatory clause. And that's one of Justice Scalia's landmark majority opinions, one of his finest opinions, of course, was the careful analysis of the text and history of the precise words of the Second Amendment. And what I think is interesting on that point about Justice Scalia and about the court in that case is all 9 justices did a heavy textual analysis. To your point about his methodology having a lasting impact, that's what they all did. They disagreed about how to interpret that prefatory clause, but no one said, who cares what the words say? They all went deep into the words, and that really was a legacy of Justice Scalia, but that you could see it right there in all 9 justices. Now, he disagreed very much with how the 4 dissenters interpreted those words, but he certainly would have applauded the methodology of them looking at the words.
So going forward, I was struck in McDonald, which followed Heller and incorporated it in Second Amendment interpretation of Heller into the states, that the 4 liberals didn't give any ground. They held very, very firm, and in fact, whereas they might have said, look, since Heller is established precedent and we've incorporated all of the other rights into in the main Bill of Rights to the states, we should go along here. And maybe they could have even influenced the majority opinion in a way to say, here's the possibility for more gun regulation under the Second Amendment. Instead, they didn't. They stuck very firmly against incorporation, and suggests to me that that maybe Heller is in some peril if the justices change on the court. I wonder if you agree with that.
I don't know, is the short answer. In terms of Supreme Court, that case, McDonald, and what the dissenters did, it's a tough thing for a Supreme Court justice to decide on something they really disagreed with, but the majority went the other way, when to reconcile yourself, if ever, to that majority opinion. And on some issues, you will say, okay, the court has so held, and move forward accordingly. On some issues, and I think this is true of every justice in modern times who sat on the court, you just can't get there, ever. And you continue to dissent and continue to say that decision is wrong and should be overruled. I will point out there was a Second Amendment case a couple weeks ago about stun guns, where at least in a 2-page opinion, all the justices applied Heller to a particular Massachusetts case. I don't think that case is huge significance, but it was an interesting data point in the discussion about Second Amendment going forward. You know, one of the areas that's been difficult in the Second Amendment is yes, there's an individual right, but to what extent are regulations of arms, of guns, permissible under Heller? And Section 2 of Heller is all about why there is an individual right. Section 3 is, okay, what exceptions to that right will we allow, in Justice Scalia's majority opinion? And on that, he really used a history and tradition-based test, laws that had traditionally been in place to allow certain kinds of narrow regulation of guns would be permissible. The question in many lower court cases since then has been, what's the appropriate test to apply? What kinds of other regulations are permissible? And that's been a real battleground in some of the lower court decisions since Heller. I thought Justice Scalia pretty clearly said what the test is, a history and tradition-based approach to figuring out any exceptions. I've been a lonely voice, I will say, in reading Heller that way.
In 2017, Judge Kavanaugh was at another think tank here in Washington, the Heritage Foundation, and he was asked to talk about his views between the executive and judicial branches. He also talked about how he thinks judges should handle interpreting vague or ambiguously worded laws.
There's a certain popular perception that the other branches of government, executive and legislative branches, will sort of do what they want to do and let the courts figure it out and tell them when they have overreached. You had the advantage of having served in the executive branch for a number of years. What role does, what role should the other branches play, or should they and do they, in terms of their own interpretations of the Constitution?
Well, I think everyone in Congress and in the executive branch is under a duty to consider the constitutionality of what they're doing, of the legislation, or in the executive branch to consider the legality of a regulation they're issuing under the statute in question. But let me tell you about Chevron, from this, again, building on my White House experience and general executive branch experience. What does Chevron do? What's the real world impact in the executive branch? So if you know that courts are going to defer to a reasonable interpretation of an ambiguity, and you think, boy, this statute doesn't really do what we want to do here, but maybe we can convince the courts that it's ambiguous, and then we can do it. And we have this huge policy objective, and we ran for office on this, and we were in the snow in Iowa running on this, and let's just call it ambiguous and hope for the best. That happens. That is a real world phenomenon. That is how Chevron doesn't just affect the courts, but then it migrates to the executive branch. Understandably, because if you're an executive branch official, you want to kind of go to the edge of the line. You want to push the envelope right to the edge. Chalk on your toes, as is said sometimes in the national security context. And so Chevron has this impact, I think, in the executive branch as well. But in terms of constitutional issues, yes, Congress is under a duty, a responsibility to consider constitutionality. So is the executive branch. But the courts, Marbury versus Madison, as General Meese talked about in the July 9, 1985 speech, Marbury versus Madison establishes critically, and I think the structure and intent of the Constitution established, that the judiciary has the final word on whether Congress or the executive branch has overstepped constitutional limits in a way that violate individual rights. So a few months ago, I told John Malcolm that I would talk tonight about the separation of powers. And I suppose that was not really a limiting selection of a topic for me, because if you were in my judicial chambers at really any point, you would hear me often saying to my clerks, every case is a separation of powers case. And I believe that. Who decides is the basic separation of powers question at the core of so many legal disputes. And the bread and butter of our docket on the D.C. Circuit is interpretation of statutes, usually when deciding whether an agency exceeded its statutory authority or statutory limits. That question of policing the balance between the legislative and executive branches, our administrative law docket, constitutes one of the most critical separation of powers issues in American law. And the most important factor is the precise wording of the statutory text. If you sat in our courtroom for a week or two and listened to case after case after case, and I do not advise that for anyone who wants to remain sane, but if you did that, you would hear judge after judge from across the ideological spectrum ask counsel about the precise wording of the statute or regulation at issue. Statutory interpretation has improved dramatically over the last generation. Statutory text matters much more than it once did. If the text is sufficiently clear, the text usually controls. The text of the law is the law. As Justice Kagan recently stated, we're all textualists now. By emphasizing the centrality of the words of the statute, Justice Scalia helped bring about a massive and enduring change on the Supreme Court and in American law. But more work remains. In my view, certain aspects of statutory interpretation are still troubling. And as I will explain, one primary problem stands out. To begin, one overarching goal for me is to make judging a more neutral, impartial process in all cases, not just statutory interpretation. The American rule of law, as I see it, depends on neutral, impartial judges who say what the law is, not what the law should be. Judges are umpires, or at least should always strive to be umpires. In a perfect world, at least as I envision it, the outcomes of cases would not often vary based solely on the backgrounds, political affiliations, or policy views of judges. This is the rule of law is the law of rules. The judge is umpire, the judge who is not free to roam in the constitutional or statutory forest as he or she sees fit. In my view, too, this goal is not merely preference of mine, but a constitutional mandate in a separation of powers system. Article 1 assigns the legislative branch, along with the president, the power to make laws. Article 3 grants the courts the judicial power to interpret those laws in individual cases and controversies. When courts apply doctrines that allow them to rewrite the laws, in effect, they are encroaching on the legislature's Article 1 power. But this vision of judge as umpire raises a natural question. How can we move toward that ideal in our judicial system when judges come from many different backgrounds and may have a variety of very strong ideological, political, or policy predispositions? To be sure, on occasion, the relevant constitutional or statutory provision may actually require the judge to consider policy and perform a common law-like function. Federal Rule of Evidence 501 is a good example. But many statutory cases involve interpretation of a statute's text. Under the structure of the Constitution, Congress and the President, not the courts, possess the authority and responsibility to legislate. As a result, clear statutes are to be followed. Statutory texts are not just common law principles or aspirations. This tenet, adhere to the text, is neutral as a matter of politics and policy. The text may be pro-business or pro-labor, pro-development or pro-environment, pro-bank or pro-consumer. Regardless, judges should follow the text where it leads.
So sticking with the theme of your presentation about statutory interpretation and constitutional imperatives, I wanted to touch on one aspect that you didn't address. Is there any hope that the courts can devise an objective way of limiting congressional delegations of power to agencies and thereby in some way revivifying the non-delegation doctrine, or is that too much water under the bridge?
Well, I think the way it's working right now is there is a doctrine related to the Chevron doctrine that I'll mention that deals with non-delegation issues or broad delegation issues. So I mentioned the Chevron canon. If an agency is given authority and the statute is ambiguous, defer to the agency. But for the last 20 years, there's been a very important exception to that. It's really don't apply Chevron and, in fact, presume a non-delegation of the agency in cases involving so-called major questions. And this was in the Brown and Williamson tobacco case in the late 90s. It was invoked by Justice Scalia in the UARG versus EPA case a few years ago. This is a critical doctrine, in my view, in the current administrative law world and how it's going to be applied. I've written about it in a few cases that are out there, and I think it's quite important. Now, so what does the doctrine do? It says if the issue is a major issue, a major question, I call it the major rules doctrine. If it's a major rule, then you don't actually defer to the agency's interpretation of the ambiguity. In fact, you presume that Congress did not delegate to the agency the authority to adopt, to issue a major regulation on the issue. And Justice Breyer, actually, in the 1980s, first articulated something like this in law review articles. And then, like I said, the Supreme Court adopted it in the late 1990s. Actually, there are cases that appeared in some form before that. Even Justice Rehnquist, frankly, in the 1980 benzene case, articulated it. And I think that's a really important doctrine right now for cabining broad delegations to agencies. In other words, if you're concerned about agencies taking vague delegations and doing massive agency rules, this major questions doctrine is critical. And you see it even in King versus Burwell. The Chief Justice referred to it after the UARG opinion. Now, two things, I'll be quicker. Two things on this. How major is major? How major is major? Money, people affected, what? I threw out some things in a dissent I wrote last year. I think it was last year, that should be considered. But that's an important debate. Some rules are obviously major under any conception, including the one I was writing about at the time, in my view. So that's one issue that is difficult with the major rules doctrine. But that is a piece of the non-delegation story. The non-delegation doctrine does not, under current Supreme Court precedent, have much teeth, but the major question doctrine is an important cabining of broad delegations in a way that I think is putting the brakes on some of what some agencies have done with somewhat limited and vague delegations to issue massive rules. Judgments about ambiguity can be dangerous because they can easily be biased by strong policy preferences that the makers of the judgments hold. Because judgments about clarity versus ambiguity turn on little more than a judge's instincts, sometimes, it is harder for judges to ensure that they're separating their policy views from what the law requires of them. And it's not simply a matter of judges trying hard enough. Policy preferences can seep into ambiguity determinations in subconscious ways. As a practical matter, of course, judges don't make the clarity versus ambiguity determination behind a veil of ignorance. Statutory interpretation issues are all briefed at the same stage of the proceeding, so a judge who decides to open the ambiguity door already knows what he or she will find behind it. Unfortunately, moreover, the clarity versus ambiguity question plays right into what many consider to be the worst of our professional training. As lawyers, we're indoctrinated from the first days of law school to find ambiguity in even the clearest of pronouncements. It is no accident that the most popular law school exam preparation book is titled Getting to Maybe. The problem of difficult clarity versus ambiguity determinations would not be quite as significant if the issue affected cases only at the margins. But the outcome of many cases turns on the initial and often incoherent dichotomy between ambiguity and clarity. Determinations of ambiguity are the linchpin of statutory interpretation. Now, a number of Supreme Court decisions, really important ones, have implicated the clarity versus ambiguity problem. Consider some of the cases that have turned on constitutional avoidance canon in the recent past. The NFIB healthcare case, the Namundo voting rights case, the Wisconsin Right to Life campaign finance case. Those were hugely significant cases, each of which turned to a significant extent on an initial question of whether the relevant statute was clear or ambiguous. If the statute was ambiguous, then they can resort to constitutional avoidance. If the statute is clear, no. All of those cases were important, and they were all decided on the basis of a difficult evaluation of clarity versus ambiguity. Same with Chevron deference. As Justice Scalia explained 25 years ago, quote, "How clear is clear? It is here, if Chevron is not abandoned, that the future battles over acceptance of agency interpretations of law will be fought," end quote. And in fact, the court has skirmished, and our court particularly has skirmished over exactly this terrain numerous times in the last 25 years in hugely significant cases, each of which turned to a significant extent on an initial question of whether the relevant statute was clear or ambiguous. All these cases came down to what turns out to be an entirely personal question, one subject to a certain sort of ipse dixit. Is the language clear or is it ambiguous? No wonder people suspect that judges' personal views are infecting these kinds of cases. We have set up a system where that suspicion is almost inevitable because the reality of the ambiguity versus clarity determination causing that is almost inevitable. Of course, in characterizing some of these decisions as examples of the problem, I want to be clear, I'm not in any way suggesting that the judges themselves are acting in an improper political manner. To the contrary, in my experience, most judges apply the doctrine as faithfully as possible. But too much of the current statutory interpretation regime revolves around personally instinctive assessments of clarity versus ambiguity. This kind of decision-making threatens to undermine the stability of the law and the neutrality, both actual and perceived, of the judiciary. After more than 11 years on the D.C. Circuit, I have a definite sense that the clarity versus ambiguity determination, is the statute clear or ambiguous, is too often a barrier to the ideal that statutory interpretation should be neutral, impartial, and predictable among judges of different partisan backgrounds and ideological predilections. And my point should not be misunderstood. Statutes will always have ambiguities. That is the nature of language, including Congress's language. We cannot eliminate or avoid ambiguities or wish them away. But even though ambiguity is unavoidable as a practical matter, perhaps we can avoid attaching serious interpretive consequences to binary and ambiguity determinations that are so hard to make in a neutral, impartial way. In other words, instead of injecting the ambiguity problem into the heart of statutory interpretation, we can consider whether to sideline that threshold inquiry as much as possible. What is the solution? Here's one idea. Judges should strive to find the best reading of the statute. They should not be diverted by an arbitrary initial inquiry into whether the statute can be characterized as clear or ambiguous. In other words, we can try to make sure that judges do not, or at least only rarely, have to ask whether a statute is clear or ambiguous in the course of interpreting it. Instead, statutory interpretation could proceed in a two-step process. First, courts could determine the best reading of the text of the statute by interpreting the words of the statute, taking account of the context of the whole statute, and applying any other appropriate semantic canons of construction. Semantic canons, by the way, are really just a fancy way of referring to the general rules by which we understand the English language. Second, once judges have arrived at the best reading of the text, they can apply, openly and honestly, any substantive canons, such as the absurdity doctrine, or settled plain statement rules, such as the presumption against extraterritoriality, the presumption of a mens rea requirement, the presumption against retroactivity, that might justify departure from the best reading of the text. Under this two-step approach, few, if any, statutory interpretation cases would turn on an initial finding of clarity versus ambiguity in the way that they do now. Now, to be sure, determining the best reading of the statute is not always easy. But we have tools to perform that task and communicate it to the parties and the public in our opinions. Why layer on a whole separate inquiry? Is the statute clear or ambiguous that does not help uncover the best reading and that is inherently difficult to resolve in a neutral, impartial, and predictable way?
Up next, C-SPAN spoke to some of those who know Judge Kavanaugh the best, those who've worked for him and those who have known him for years. First, we'll hear from 4 lawyers who worked as law clerks for Judge Kavanaugh. Then we'll hear from childhood friends Scott McCaleb and Kristen Silverberg, a friend and former colleague from his days in the Bush White House. Justin Walker, you clerked for D.C. Circuit Court Judge Brett Kavanaugh in 2010 to 2011. Why did you want to work for him?
Oh, well, I had heard that Judge Kavanaugh was a brilliant jurist and also an extremely down-to-earth, great guy. And over the course of my year clerking for him, both of those things were very much confirmed. So that's why I wanted to work for him, and it was a great thrill.
Who did you hear that from?
Well, I heard it from students. I heard it from faculty. I probably read it. I think just this past week, President Obama's former Solicitor General said Judge Kavanaugh was a brilliant jurist. So I think left, right, and center, people were saying Judge Kavanaugh is just a great judge, brilliant lawyer and a wonderful person to clerk for.
What was your first impression of him?
Well, I met him when he taught a separation of powers class at law school. And my first impression was that this is someone who loves the Constitution, who is up here for 3 weeks in January in the middle of snowy Cambridge.
Okay.
And not only was he teaching 3 hours a day about the Constitution that he loves, but he had 5 hours of office hours every day, which was unheard of in law school. And he was there to talk about the law and talk about other things too, and it was just a great way to get to learn from him.
Did you take advantage of those office hours?
I did. Sometimes we talked current events and sometimes we talked Constitution.
Why did you talk current events? I mean, how did that come up?
Oh, well, separation of powers is all about the role of the judiciary, presidential power. This was, it's almost always in the news. So he encourages his students to think about every issue from all perspectives and to connect the kind of abstract constitutional law topics to real-world applications, because he told us in the class, and he has said in many of his opinions, that there are lots of protections in the Constitution that protect liberty, but the most important protection is the way that the separation of powers, the structure of the Constitution, protects individual liberty.
Why did he have office hours and 5 hours nonetheless?
Well, I think that he is someone who was there to teach and to mentor, and I think he is that kind of a person, not just for students. There was a letter written by an ideologically diverse, large group of his students, and they said, we loved learning from Judge Kavanaugh because he really wanted to help us explore the Constitution. Imagine whatever topic you enjoy most in your life, imagine getting to explore it with other people who are just as excited about it and just as interested in it as you are. I think that's part of the experience of taking constitutional law from Judge Kavanaugh.
And then you went on to clerk for him after taking class from him. What did you learn about that was different from the class about his personality, about who he is?
Well, he was very much the same person in chambers as in the class, in that he was very thoughtful about how he went about each case. He was an independent thinker who wanted to hire clerks from different perspectives and also to look at each case in a fair-minded, open-minded way. And then one of the things that he used to say, one of his, I don't know if you want to say mottos or catchphrases, but he would say in class and also in chambers that every case is a separation of powers case. And what he meant by that is that even if that claim is not raised, each case challenges the judge to remember the judge's proper limited role in the tripartite structure of three branches of government, where the executive and the legislature make policy, and the judiciary applies the law that other people have written. They don't invent the law themselves.
What did he tell you about your background, your perspective, that he wanted on his team?
Well, I don't know why he hired me. I'm sure glad that he did. I felt very lucky to get to be a clerk for him. I don't know why.
When you worked with him on cases, what do you remember about his style? His style to either asking questions, his writing style, his approach in oral argument?
Well, his approach to oral argument, I think, is a great balance between asking hard, challenging questions that really go to the heart of the matter, but doing it in a way that is polite and respectful to the advocates. And you see both extremes from other judges. I'm not here to name names, but there are judges who just don't ask particularly useful questions. And then there are judges who ask good questions, but they do it with such a hostile tone. And sometimes they even go beyond that, and they're just asking questions for the sake of trying to make an advocate look bad. Judge Kavanaugh was never like that. He was very polite, very respectful, but he would ask tough, challenging questions.
Where do you think he learned that from?
I think it's somewhat consistent with his personality. I mean, he takes very seriously the role of the judge as an independent explorer for the meaning of the law, but he also doesn't take himself too seriously. And so, he's there to be a judge's judge and to follow where the law leads. He's not there to showboat or brag or show how smart he is.
Did he talk about influences in his life, throughout his life, mentors, parents, and what would he say?
Well, I think both of his parents were mentors. His dad was an extremely hard worker, and Judge Kavanaugh got that from his dad and his mom, I'm sure. When I was clerking for Justice Kennedy, he would talk about what a hard worker Judge Kavanaugh was, because Kavanaugh had been a clerk for Kennedy when he was a young attorney, and Justice Kennedy would say, I'd walk into chambers and Brett would be there at his desk in the morning, and then he'd be there at his desk at night, and I'd say, Brett, go home, you need a life outside of work. And then I'd come back in the morning and he'd be right there at his desk working away again. So I think he got that work ethic from his parents, and then I think from his mom. His mom was a public school teacher in the DC area. She then went to law school, became a prosecutor at a time when there weren't a lot of female prosecutors, and then became a state court judge at a time when there weren't a lot of female state court judges. And so I think that that was a strong influence, not just in what I'm sure she said at the dinner table, but in what she did and what he saw every day. You know, Judge Kavanaugh has hired a majority of his 48 clerks have been female. Many of them have gone on to clerk for the Supreme Court. And that's a testament to how important Judge Kavanaugh thinks supporting equality and opportunity in the profession are. Lisa Blatt, former clerk for Justice Ruth Bader Ginsburg and one of the leading Supreme Court advocates in the country, recently wrote a column where she said, I'm a liberal feminist lawyer and the Democrats should stop attacking Judge Kavanaugh. She said, other than Justice Ginsburg, he's probably done as much as anyone to support opportunities for women in the profession.
How are you and other clerks organized to speak on his behalf? Who is doing the organizing, and why do you feel that why are you taking on this role? Well,
I don't know how formal the impression is that the organization is. In my case, I'm a assistant law professor from the University of Louisville. Before the nomination, on occasion, people would, say, do you want to speak at this conference? Do you want to speak at that panel? And since the nomination, there have been a few more of those requests, and most of them have been to speak about Judge Kavanaugh, and I've been thrilled to do it because, there are plenty of things that I'm inarticulate enough that they're hard to talk about. But talking about what a great judge Brett Kavanaugh is really a pretty easy thing to do.
What impact has he had on you
my gosh,
in your life?
I certainly wouldn't be where I am without him, and that goes back to what I learned from him as a teacher and as a boss about approaching the law in a way that respects the other roles of the branches and the limited, humble role of the judiciary. He reinforced that by all means. But then every time I've had a career decision in my life, I've called Judge Kavanaugh, and every single time his response is the same. He'll make time, and he'll give advice, and he'll ask if he can help. And through thick and thin, Judge Kavanaugh has been there for me, and I don't know that there's any or many job opportunities that I've gotten since then that he wasn't a reference for or a supporter for. And certainly don't think I would be where I am without him.
Do one of those phone calls stand out to you, and what and something he said?
No one stands out. I guess it's not even the specific advice that he gave, although sometimes that was really important. It's just that he always made time. And I know I'm not alone. He's had 48 former clerks, and he takes so seriously his role as a mentor for young attorneys of all backgrounds, ideological backgrounds, diverse backgrounds. And so he's a great judge, but what has mattered the most to me in my life is that he is a truly good man.
When you were leaving the clerk position with him, what did he say to you about your career going forward and the impact of that time with him and what it would have on your career?
Well, I remember him telling some outgoing clerks that, getting to clerk at the Supreme Court next was an opportunity that we should not take for granted, not bring with us a sense of entitlement, and that we should approach our role as humble agents for, in my case, Justice Kennedy. And so that's always something I tried to remember as a clerk, was that, the clerk is not the one who is nominated by the president and confirmed by the Senate. And so you're there to help and advise and not forget that you are an agent for someone else. So that was helpful advice. And then, he also gave advice on the last day of class to the whole class that I remembered. And one of the things he talked about was the importance of loyalty. And that's something I've seen him live. He's been just beyond loyal to me, always. But he also talked about the importance of family. And, this is someone who's a judge on the second highest court in the country, who's had lots of important positions throughout his career. And here he was talking to us about no matter how big your job is or how important you think it is, you have to make a place, make a priority, make your family a priority. And I think he's also lived that. He coaches his little girls' basketball teams. He's a devoted husband to his wife. And, we would go over to their house for their holiday party. He always had the former clerks over. And you could just see this family that, truly loved each other, and that, he's not a dad. He's a carpool dad.
And what does that mean?
Well, that means, he might be the one driving the girls to basketball or driving them to school. I think, he's not, I'm sure there are lots of fathers out there that love their kids, but don't always make the time because of their jobs. And Judge Kavanaugh wasn't one of those dads. He loved his job, but he also loved his family, and he spent plenty of time working hard, as we talked about, in chambers. But he also spent so much time with those girls, and they're the apples of his eye.
Justin Walker, thank you for the conversation.
Thank you.
He was approachable. He was not always serious, and a healthy mix of both. We have clerk reunions every year that are pretty informal. This is going to a baseball game in standing room seats and having a beer and watching the game from the outfield, and really not watching the game very much, but just talking with him, with his wife, and with other clerks. Mm. This is not a person for unnecessary formality necessarily. The clerk reunions are not black tie affairs. This is someone who does not take himself too seriously, even while he takes the job and the responsibility very seriously. So even seeing that balance in a person who was, again, showing you through the hours he was working and the care he was putting into it, how much he revered the law and the awesome responsibility that had been placed in him. But that doesn't mean you have to be distant or remote, and he's certainly not those things.
How so?
Well, this is a Budweiser guy, not a Bordeaux guy, I think is maybe one way to say it. I mean, he's a real person. This is someone that we got to watch as a parent of young children, and loves his two girls very much, but current clerks now know him as a basketball coach, in addition to knowing him as a judge. And someone who just does not put on airs or take himself in the judicial role too seriously at all, and is also very available to current and former clerks.
When did you meet Judge Brett Kavanaugh?
I met Judge Brett Kavanaugh actually soon after he had been confirmed. I believe it was either May or June, must have been June 2006, in his chambers, and was actually his first law clerk hire.
So this was to the D.C. Circuit Court of Appeals?
To the U.S. Court of Appeals for the D.C. Circuit, exactly, yes.
What was your first impression of him when you went for that interview to get this clerkship?
Well, as you can imagine, like the typical recent law school graduate, I was a little bit nervous, but he immediately, put me at ease and seemed very approachable and nice and, interested in, what my qualifications would be and understanding of the role of a law clerk and the law, but also seemed interested in me as a person. I could tell right away that this was going to be a warm boss were he to hire me and someone who would be looking to kind of mentor me and give me that training that you're looking for your first year out of law school.
What struck you about his personality during that time?
How very kind he was and generous with his time, with his personality. It being the first year, his investiture, his ceremony where he took his oath and had friends come in happened that year, so we got to meet his parents. And his oldest daughter, I believe, was 1 or 2 at the time. And just being able to see him engage with people from a wide, all of his walks of life was great. And, even kind of fun things that first year. My co-clerk and I, when we were first hired, there's a security process where you have to get your badge and your key. So at the beginning, my co-clerk and I could not let ourselves into the office on our own. And so just the judge, very easygoing, nice. He was always the first one there. Those first couple days would have to walk down the long hallway, usher us in. And you could just see this sense about he's a real person, incredibly humble, willing to just be a normal guy. He's the kind of person you love to have dinner with, grab a beer with. And so we got to have a lot of those casual lunches with him that year as well.
Porter Wilkinson, how do you know Judge Brett Kavanaugh?
I clerked for Judge Kavanaugh in 2007, 2008, which was his second year on the bench.
And how did you go about getting this position?
Well, I interviewed with him in the fall of 2006 for a clerkship a year after, which is pretty typical. But he joined the D.C. Circuit in May of 2006. So I was aware of Judge Kavanaugh's sterling credentials and his reputation of having such a great intellect. But he really wasn't very well known as a judge at the time. He had probably only heard one set of cases and might not even have written an opinion at that time when I interviewed with him.
What was the interview like?
The interview was great. Judge Kavanaugh is a warm, encouraging, uncommonly decent man, and he was very approachable from the start. He asked me a lot about myself. He didn't have the conversation focus on him at all, and he asked about my background being a lacrosse player at the University of North Carolina, and about my family, and about my experiences in college and in law school.
What did he tell you about the job that you would be taking on, clerking for the D.C. Circuit Court of Appeals, a judge on that bench?
Well, he told me a little bit about his approach to cases, the way that he asks his clerks to help him prepare. Judge Kavanaugh is a very hard worker, and he approaches every case with an open mind, reads the briefs from the parties, understands the law, and understands the factual record. And he expects his clerks to help him in that endeavor and to work really hard in knowing the case as well as the advocates do.
How many hours were you putting in?
That's a great question. I don't remember.
It's a blur.
It's a little bit of a blur, but my 3 co-clerks are now some of my best friends. So the hours spent in chambers were just as much fun as our hours spent outside of chambers. So I can't even really remember now what our office hours were, but it was a really fantastic year.
Walk us through a case. How would you approach it with the judge?
Mm-hmm. So a case would come in the door, and Judge Kavanaugh would always approach the case with an open mind. He would never bring any personal or policy views to the case. We would read the factual record, understand what had happened, and understand what the law was. And that required reading the underlying cases, of course, reading the text of the Constitution or the statute or the law at issue, and applying it faithfully without regard to the litigants. And then Judge Kavanaugh would often invite his clerks into his office, and we would banter about ideas. He wanted to understand the strongest arguments on both sides of the case, and he would welcome pushback, and he would welcome dissent, and then we would go into oral argument, and he would ask the litigants any questions he had that were unresolved based on the work he had done so far, and make up his mind to how he was going to rule in the case.
Does one of those bantering sessions stand out to you?
No, I can't say that it does. I just have this fond recollection of us all sitting around and talking about the law, exchanging ideas. And one of the best parts about a clerkship is it really is an apprenticeship, getting to see the judge, how his mind works, how he approaches cases, how he balances competing interests. And so I remember just always being struck by Judge Kavanaugh's intellect and his impartiality and his way of deciding cases. But I really don't remember any particular discussions.
So when it came to hear the case, what do you remember the judge saying about that in the process?
It was very important to the judge to come to the bench very prepared. He wanted to know the case as well as the litigants. He thought that he owed the litigants that to understand the case, and he wanted to ask questions, anything he didn't understand or anything that he wanted to delve a little deeper into. He always came with an open mind and wanted to make sure that he asked questions of both sides, and you often couldn't come away from oral argument knowing which way the judge was leaning.
Why is that?
Because he would ask so many questions of both sides. And so he would be asking questions of the pressing the weaknesses of one side and pressing the weaknesses of the other side. So you wouldn't know which way necessarily he was leaning in deciding a case because he was so fair in questioning the advocates.
What came next, and what role did you play as the clerk?
So next came drafting the opinions. So Judge Kavanaugh would ask his clerks to write a first draft. And from there, Judge Kavanaugh would spend an incredible amount of time refining and editing opinions to make sure that they were clear and well-reasoned and precise. Drafts, we could often turn dozens, I don't want to say hundreds, but maybe that many drafts. And
we've talked to other clerks, and they said it was approaching,
I think it could be.
At least 50 sometimes,
yes.
Sometimes more.
Yes, so even though the clerks wrote the first drafts, I can assure you that what came out of chambers was Judge Kavanaugh's writing. And he would even edit his own work multiple times. Sentences that he had written, he would rewrite 2, 3, 4 times. And that was really wonderful as a young lawyer to see that iterative process and to understand that even someone as accomplished and as smart as Judge Kavanaugh would continue to perfect his own writing.
What rules do you remember he had?
That's a great question. I do remember one time we had a conversation about adverbs, and he felt that usually adverbs were unnecessary, and sometimes in legal writing they can even come across as a little bit snarky. And to show me this, he took one of the memos that I had written, maybe a lengthy memo, 10, 20 pages, and crossed out every adverb in the memo and said, read it. And he was right. Often adverbs aren't necessary. And so now in my own writing, when I go back and I take out all the adverbs, and sometimes that means I refine my verb choice, and sometimes it means I go back and add the ones that are most important. But I've taken that rule with me in other parts of my career.
Did he have any sayings about the Constitution or about law or any about life?
I don't know if he said this, but I really associate him with the gist that there's no substitute for hard work. He is a prodigious work ethic. He's known from his clerks and from the other judges on the circuit of how hard he works. And he was the first job that I had outside of law school, and so that's something that I've really taken with me, that there are no shortcuts in the law. You have to understand the case, you have to understand the law, and that's true for the rest of life as well.
What did you learn about him throughout this time that you spent with him, long hours? What did you learn about his personality? Not his judicial philosophy, but what did you learn about his personality, maybe his personal life, that you still remember today?
Oh, Judge Kavanaugh is a lifelong Maryland basketball fan. I grew up in Charlottesville, Virginia, and went to UVA Law School, and I went to UNC undergrad. So we had some conflicting allegiances, and that led to a good-natured rivalry throughout my clerkship and beyond. And I can say firsthand that the judge is able to keep a strong personal relationship even in the face of fierce opposition.
So this rivalry has continued. In what way? After you left the clerk position, how did it continue?
Oh, it has definitely continued. We'll email each other before a big matchup or after a big matchup. And of course, Maryland is not in the ACC anymore. So Maryland doesn't play UNC as often in the ACC tournament, but they'll still have matchups. And so we'll email a lot about those games. And he's also a women's lacrosse fan. I played women's lacrosse in college, and his 2 daughters play. His cousin, Megan Ward, was an all-star goalie in the goal for UNC when they won their 2 national championships in 2013 and 2016. So he became actually a UNC fan, which was great from my perspective that we were rooting for the same team.
There's been discussion about Judge Kavanaugh's views of gender inequality issues. You signed a letter along with some other female clerks. And what did that letter say? Why did you sign it?
Judge Kavanaugh is a fierce advocate for women. His mother was a trailblazer in the legal profession at a time when it was even more dominated by men than it is today. And Judge Kavanaugh has hired a great number of women. 25 out of his 48 clerks are women. 21 of those 25 have gone on to clerk at the Supreme Court. He has not only hired a great number of women, but also gone on to champion them. So again, a lot of them have gone on to clerk at the Supreme Court, but beyond that, throughout my career, Judge Kavanaugh has called, and even if I wasn't looking for a job, he would say, have you seen this opportunity? You should consider it. And he'll give us that nudge to pursue something, even if we wouldn't have gotten it, if we wouldn't have reached for it on our own. And he does that for all of his clerks, and in that way, he is really promoting women and doing his best to diversify the profession.
When you were clerking, were there other men that were clerking? Were there men clerking along with you when you were there? And so, what did it ever strike you that he favored one or the other, or did it ever even come to mind?
Absolutely not. Judge Kavanaugh treats everybody equally and fairly, and it never even occurred to me that he would treat me differently or that he would have different expectations. And he's never, in my opinion, treated anybody differently. He's a firm believer in equality.
Do you remember him talking about his mother and the impact she had on him?
I do. I remember from very early on that he had a working mother, that he firmly believed of the importance of equality in the profession, in the workplace, and beyond.
You also clerked for Chief Justice John Roberts.
I did.
Any similarities between the two?
Very similar in demeanor. They both are just unfailingly gracious in every interaction that they have. I don't think that Judge Kavanaugh or the Chief Justice ever raised their voice at me. Mm-hmm. Even when I made a mistake, even when I may have deserved it, I just remember so much decency in how they treated me and how they taught me and how they treated other people around them. And I think the only time actually I've heard Judge Kavanaugh raise his voice was at a sporting event to root on his team.
What do you take away from your experience with him? I mean, you and other clerks have been advocates for him in this whole process. Why?
Well, as I mentioned earlier, Judge Kavanaugh's work ethic is really something that has stuck with me, and understanding that you can't take shortcuts and there's no substitute for hard work. But more than that, Judge Kavanaugh is a man of just such high moral integrity in everything that he does, in his interactions with his family, with his community, with his colleagues, and I've really tried to live up to that ideal.
And that is why you and others are speaking on his behalf?
Absolutely. I think that he is just an upstanding, decent, warm, encouraging man. And a lot of people have said in this process that whether someone's a good person doesn't matter. All that matters is their jurisprudence. And I couldn't disagree more. I think that a person doesn't cease to be the person they are when they put on a robe. And Judge Kavanaugh's character, his integrity, and his work ethic, he will bring to the bench, and it will make him a better colleague and a better jurist.
Porter Wilkinson, thank you for the conversation.
Thank you.
No, Judge Brett Kavanaugh.
Well, I guess I met him, gosh, it's 38 years ago, 1980. I was a freshman in high school. He was a sophomore, but we went to competing high school. There are two Jesuit high schools in Washington, Gonzaga, down on Capitol Hill, and Georgetown Prep. Brett went to Georgetown Prep, I went to Gonzaga. But even though there's kind of a very intense rivalry between the schools, there's also really, a great camaraderie amongst the students from both schools. There's a lot of overlap. Brothers will go to both schools or each school. So I had lots and lots of friends and actually family members as well who went to Georgetown Prep. So I got to know Brett really through common friends and playing sports against him. He was a pretty good football player, pretty accomplished basketball player, certainly much better than I. But and so really the genesis of our friendship was through sports and competing against each other.
What kind of personality did he have? Does he still have?
Yeah, well, first of all, he's great company. He's one of these guys who loves to have fun. Has an infectious laugh. and is just a, kind of an all-around terrific guy. I guess, I always had kind of a complete respect and admiration for him because he excelled both academically and athletically, and not just through, raw talent or raw intellect. He was one of these guys who he worked so hard, and yet he was, a devout churchgoer, and he always was, the most humble guy in the room, Brett Kavanaugh does not talk about Brett Kavanaugh very frequently, and when he does, it's usually with great reluctance.
Did you get to know his family, his parents, and what impact do you think they had on him?
Yes, I do know both Martha and Ed, and Judge Kavanaugh, the real Judge Kavanaugh, as we like to call her. And I think that they both had different influences on him. They, certainly his mother. Becoming a judge after being a teacher, being a lawyer, prosecutor, and a judge, I think, was something that Brett really respected. And I think it gave him, a real role model from the legal perspective. His father is also, a very accomplished guy and a wonderful personality, a wonderful, man. And so I think that he gave Brett, from a personal perspective and kind of how a responsible adult should behave, he gave him, that really fine example.
When you first got to know him, you weren't responsible adults, or maybe you were in high school. I mean, what did you guys do? What was fun?
Well, these were back in the salad days of Washington sports. So it was. For example, 1983 was the Georgetown Hoyas won the NCAA championship. The Baltimore Orioles, we didn't have the Nats then. We were all Orioles fans. They won the World Series. The Redskins went to the Super Bowl. They won a Super Bowl one year and lost the next. So it was really what a lot of what we did really centered around the DC sports scene. And so heroes for a lot of us at that time were, guys like Cal Ripken and Riggo, John Riggins, save for the Sandy Baby comment that he made to Justice O'Connor. But a lot of what we did centered around our own athletic events and going to see sporting events and just having a good time with each other.
Outside of sports, who were his heroes? Who were his mentors?
Yeah, I don't really have a good answer on that. I think that, we were all probably a little more shallow than we should have been back then, and the heroes really were guys like that. Brett was definitely, more mature than the rest of us, and so he may have had, heroes. I don't think at the time he had any, real judicial heroes besides his mother. But, he is one of those guys who was always kind of just a little bit more mature and made better decisions than the rest of us. And when I think of him, I recall, that scene in It's a Wonderful Life where Peter Bailey and George Bailey are sitting at the dining room table, and the father tells the son, George, you were born old. And the son says, how's that, Dad? That's my trick here. And he says, you were born old, George. And I always kind of felt like Brett was born old. He was born, just more mature, had better decision-making than certainly the rest of us.
Did he forecast a career in law and being a judge? Did he ever say, I'm going to sit on the Supreme Court one day?
He didn't say that, but he absolutely did forecast, an interest in the law. I can't recall the first time that he and I talked about it, but it was certainly clear by the time that we were in college, and he was at Yale and I was at Brown, that we both had an interest in the law. We both wanted to go to law school. That was what our destinies were going to be, and so it was absolutely clear, certainly, by early college, late high school, that was a path that we were both interested in pursuing.
What were those conversations like about pursuing a law degree?
I think it was certainly from I don't know if it was I or he who said it, but certainly it was said that it was this was a profession that was as close to kind of competitive athletics as you can find. There's going to be, in litigation, a winner. There's going to be a loser. You don't want to get outworked by your opponent. You're going to bust your butt to be as prepared as you possibly can. There's going to be a referee, the judge, and so certainly that was a conversation that I recall, at some point having with Judge Kavanaugh. I don't recall whether he was the one saying it to me or I was the one saying it to him, but it's certainly a back and forth that I remember.
As his career has progressed, what has he said? What kind of conversations have the two of you had about working for the President, George W. Bush, and then going on to serve on the D.C. Circuit Court of Appeals?
We don't have a lot of conversations about the law, honestly. Our conversations, this is, for as great an intellect as he is, and for a guy who has been around politics for a mighty long time, this is a guy who's not wonky at all. This is a guy who is, on weekends, he's not sitting around debating and studying politics. And what he's doing, he's out watching ball games. He's watching girls lacrosse games, women's lacrosse games, women's basketball games, football games, baseball games, hockey games, and he's just very passionate about sports really at every single level. Our conversations these days focus more, around those topics and around our own children's, events. And this will give you kind of an idea of, how invested in athletics he is. Like, I remember he called me once this spring. My son plays, lacrosse at Brown, and I remember him calling me, one day and saying, "Hey, I watched Luke's game last night." And, well, my son's game was like live streamed, on some live stream broadcast. It wasn't on, ESPN or something. And so I just thought to myself, what do you mean you watched his lacrosse game on live stream? So he's just that sort of guy. So a lot of, what we talk about these days centers around Margaret and Liza's, basketball and lacrosse games and my own son's athletics.
What can you tell us about his wife, his decision to, when he met her, to date her and marry her?
Well, what I can tell you is, like many of us, he outkicked his coverage. I mean, if you haven't met Ashley, she's about as lovely a person as you will ever meet. She is smart, she's, wonderful, compassionate, kind, generous, just, exactly the sort of woman you would want your daughter to grow up to be. And so he absolutely outkicked his coverage with Ashley, and his daughters. It's no surprise they are both Margaret and Liza are wonderful and kind of superstars in their own right. They go to a school where my mother-in-law is the vice principal, so I know everything that's going on with them. And Liza, I take a special interest in, as she's my goddaughter, and so. As both of them are really superstars, and it's no surprise. I mean, they come by it honestly.
What's the role of religion in his life? You're his daughter's godfather. What does it play? I mean, how does it factor into the way he lives his life, and does it factor into him being a judge?
Whether or not it factors into him being a judge, I think you have to go back to the beginning and really to the time we met. And it is not just the motto of Georgetown Prep or Gonzaga or any individual Jesuit school. The Jesuit motto is to be a man for others, or a woman for others. And for a lot of people, those are just words. But for Brett, they weren't. They weren't just words. This was something he took seriously and took to heart. And so that's why you see his service to others. This is a guy who could have made mountains of money in private practice, but that wasn't what he was interested in. He was interested in serving his country, serving others in the way that he was best capable of doing. And so while he's doing that through judging and through all of the other public service that he's had in the executive branch, and even with DOJ in Judge Starr's office. This is on top of that, all of that service. That's why you see and you hear about some of the things that really he does with his free time. He's coaching the girls' basketball teams. He's mentoring underprivileged kids at the Washington Jesuit Academy. He's serving on the board of the Washington Jesuit Academy. He is, taking our widowed friend's daughter to the father-daughter dance. These are the things that he does, and so he's, serving the homeless at Catholic Charities, serving them meals. This is what Brett's always done. This is who he is. He really does, take to heart the Jesuit motto of being a person for others.
And how is it that how do your families hang out now? How do you guys spend your, not your lawyerly hours, but your friend hours together? It
usually involves, some sort of athletic event. So, I'm either going to see one of the games he's coaching, see one of the girls play, Liza or Margaret. We'll get together and watch, a football game. We'll watch, we spent some time watching some hockey games this year. So generally it somehow ends up circling, around one of those sorts of events. And it used to be that I would see him occasionally at various bar events, but not so much anymore.
Scott McCaleb, thank you very much for the conversation.
You're very welcome.
We worked together in the first term of the Bush administration. Brett was one of the superstar lawyers who came into the White House counsel in the first term, and I was in the Chief of Staff's office. We worked together. We were both working in the White House on 9/11, and we spent a lot of time together in the months after 9/11 working on legislative and legal issues related to the crisis, to keeping the country safe, to making sure the country didn't go into recession. Brett was remarkable, I think, in that time period, in part because of his open-mindedness. Those were really high-pressure times. We wanted to do everything we could do to keep the country safe. We wanted to move quickly. And Brett was one of the people who wanted all the information. He wanted to hear the arguments on all sides. He wanted to read everything, talk to everyone, and really make a thoughtful and considered decision about our policy options.
Describe the mood at that time, the pressure, and how the two of you and others worked together.
Working in the White House after 9/11 was incredibly high pressure. We were trying to move quickly. We wanted to keep the country safe. There were a lot of internal debates about the best way ahead. We were having discussions, really difficult discussions with Congress about some of our options. And so you learned a lot about a person by how they responded in that period. And Brett was calm. He was unflappable. He was open-minded about our policy options. He really wanted to hear from everyone, to hear from all sides. He was collegial. I think he helped to keep everyone on the same page and served a really important role as an honest broker in those internal debates.
What do you think makes him qualified for what he has done so far and the Supreme Court? What about your time with him specifically at the White House that makes him qualified?
Well, he's had a very distinguished legal career, obviously. He's had incredible experiences, but one of the things I think that stands out about Brett is his humility. He's one of the only very successful people in Washington who got there without ever promoting himself. I've never once heard him tout his own many accomplishments, and in fact, if you hear him talking about himself, it's usually making a self-deprecating joke. And I think humility is very important in judges. It's such a powerful job. You have the ability to overrule the decisions of our elected representatives of the people. And so you want judges who are going to approach their job with some modesty and humility. And I really trust Brett to exercise his job with a lot of restraint.
What sort of advice did he give you?
I think he's a big believer in his friends. He's a very loyal friend. He spends a lot of time trying to give other people a leg up. And in fact, I saw that with someone I was mentoring, there was a young student from Yemen who was in D.C. as part of an exchange program and wanted to learn more about the U.S. judicial system so that she could participate in Yemen's judicial reforms. And I told her, well, I do know this one judge, but he's very busy. I'll ask for time with him. And sure enough, Brett said that he would sit down with her. And the day of the meeting, she showed up about 45 minutes late, which for most important people in Washington would mean that you missed the meeting. But of course, when she showed up, Brett said, no problem, just come on in. And he spent an hour with her talking about everything she wanted to know about the U.S. judicial system.
And now Father John Ensler, the CEO of Catholic Charities here in Washington, D.C., and the former priest of Judge Kavanaugh. Father John Ensler, when did you meet Brett Kavanaugh?
Well, I can't remember exactly the date I met Brett, but it was when he was an altar boy and I was a young priest. So probably, I'd say 75 or 76, when he was, I think, 10 or 12, and I was probably 28 or so.
And where were you at the time?
There's a church called a Little Flower Church in Bethesda, and that's where he lived with his mom and dad. And grew up there, and so he was an active kid in the parish. He actually went to a different school called Mater Dei, which is up the street, about maybe 3 miles or so. But so I get to know him from that, and just a great young man who just had a lot of, just a special kid. In many ways, like all other kids. But he was, you could see he was a special kid too.
What did you see as an altar boy?
Obviously, enthusiasm. Whatever he did, enthusiasm. You saw kind of a sense of, I want to do it right. I want to be a good altar boy. I want to be good at this. A sense of, in sports, the same thing. Competitiveness and desire to be good on the field, football and basketball. So you just saw, again, not that different that you say, this kid will be a Supreme Court justice someday, but to say this is a really nice young boy.
Why do you think he became an altar boy?
Well, I think his faith is really important to him. His mom and dad's faith, Ed and Martha's faith is strong to them. And I think they instilled in him a sense of service. So at an early age, I'm going to say 12 years old, I'm not exactly sure, but say 10 or 12 years old, I think he saw there's a chance to serve. This is something I can do. I can't maybe read the readings of the Mass yet, and I can't maybe give out communion yet, and I can't obviously be a priest yet, but I could do this. This is something I could do. I'm a young man who's growing in his own maturity, and this is something that I've been asked to do it. I'm going to do it.
How did you see him grow then over the years?
Well, I saw him, through those years' experience at Little Flower, though not as much as I would have liked because he was a different school. So as a young priest, you're involved in the school heavily. You're over with the children. You teach classes to them. You're sometimes, if you're lucky, out in the playground with them. You're just in the cafeteria. You develop a relationship with them. You're kind of like their big brother to a lot of the kids there. So I didn't have quite the same contact there, but I went to Mater Dei school as a kind of semi-chaplain. I was there, maybe 6, 8 times a year. I'd see him there as well. So I didn't have the everyday contact, but I had contact enough to see this young kid's growing. I saw, again, he had some pretty good athletic skills, pretty good football player, pretty good basketball player. He was a very good student, but not showy, not intellectual, kind of like, I'm not a nerdy type of kid. I'm more of a kid who just really was smart and just did his best, but didn't, in a sense, lord it over or try to impress others with that intelligence. So I saw him growing intellectually, but a very good student. I saw him growing in his desire to be good on the basketball court and on the football field. I saw him also growing in his desire, I think, to just be a good guy. Mater Dei's, they're one of their mottos is be a good guy, be a good guy. Play hard, work hard, and pray hard. So be a good guy. So he was in that motto, in that kind of that sense of I'm going to work at my school. I'm going to play hard in my athletics. I'm going to try to be a good kid as well.
You're known as Father John. You're known as Father John to him as well. Through his younger years, did he ever? Do you remember any conversations that you had with him about his religion or morality, or just about life?
I don't remember any particular conversations. What I do remember is, a sense of, again, be a good guy, do the right thing. So you saw, again, not a specific conversation, which would happen with very few kids anyway, but you could just see the goodness that kids have. Kids are great. They have goodness. Boys and girls are good, generally good. And you'll see a couple of kids sometimes who are not so good, but most of them are really good. And so you saw that goodness. You saw that big heart. You saw that desire to help other people. I mean, he would be a kid, I'm sure, who would volunteer to do anything that would help somebody else. I mean, if there was a situation where, all right, we're going to do something, we're going to collect socks for the homeless, say, I'm in. We're going to serve a meal basically at some shelter. I'm in. You saw more of that service, that commitment to others, which we still see today.
And how has your relationship with Judge Kavanaugh grown in his adult years?
Okay, so I guess I want to say I did see him at the end of his high school career. I was involved with a lot of those kids, and so a lot of these boys and girls who I knew from grade school. Now they got to be high school seniors and all. And I was at a couple parties he was at. There's a particular family, the Ergo family, had a lot of these nice. They had 9 boys and a girl, so they had a lot of parties, big house and fun. And I remember being there and again seeing, these were not wild parties. They were just kids having fun. I don't think there was any beer drinking to my knowledge. Maybe some behind the scenes, but not we could see. But these were just kids getting together having fun. So I saw them there as well. And again, you saw goodness there. And then I kind of lost contact with them off to college, to tell you the truth. I mean, I didn't have much contact with them there. And then as an adult, probably, now it's 15, 16 years ago, he called me about his wedding. So I'm getting married. I married a wonderful Episcopalian from Texas, Ashley. I'd like to be there to be part of this if you can. And so I was preparing for the wedding, met with them as a couple. We would call pre-Cana, pre-marriage preparation. I did that with them, and then was there at the wedding with another Episcopal priest. We did it down at, I believe it was Christ Church in Georgetown. And we had a nice wedding there. And actually the president came because, Ashley was the president's secretary, and Brett was kind of his aide on many different issues. So they met at the White House, and the president and Mrs. Bush were there. And I remember seeing them there.
What struck you about their relationship when you were working with them before they took their vows? Both very dedicated to this country, one. Dedicated, I think, to to their own, using their best gifts and abilities they had. I was struck also by the love that they found in each other was it just made sense. They were working together. They were in the same political discussions. I'm sure they were dealing with the same. I'm sure it's not easy to work at the White House. I'm sure it's not. And I'm sure some of the drama there, and they had to deal with all those issues, and through that found love for each other. And then, of course, got married. So I was there for the wedding, and I was also baptized both girls. So. And as adults now, what do you talk about when you see him?
We talk, well, first of all, sports.
This seems to be a common theme.
Yeah. I mean, he loves sports. I mean, so, he's big Caps fan, a big Nats fan, Just so that's almost the first conversation, basically what's going on there. So when he comes and serves dinner here, which he's done 2 times since the nomination, before the nomination, he probably came here 10, 12, 15 times. So it wasn't just, but since the nomination, he's been here twice. Both times the Caps hat on as he served dinner to our homeless right outside the building here. He had his cap from with the large caps on it, capital caps on it, and so he's a big sports guy. So with that. We talk about sports and family. How's Ashley doing? How the girls doing? And he's a pretty ordinary guy.
Has he talked to you about his nomination? You were there when the president announced it.
No, not a lot specifically. Except I'm always excited. I mean, for all the lawyers I've talked to, these are not older than Brett. I think one of the dreams many of them have would be to go to the highest place in the court. So he's kind of reached that ultimate possibility. And I think he's very excited about it. I've talked to him about he feels that that it's going as best it can be going. I mean, he doesn't know for sure, but it's going well. He feels that that the process is going fine, and we'll see what happens. He asked me 2 days ago. I was very honored. He said after the hearing, there's a opportunity for people to get character reference. There'll be 12 people, 3 minutes each at the Senate. He said, if you don't want to do it, it's fine. But he said, I'd like you to do it. And I said, of course I'll do it. And I'll be happy to do it. And I said to him, because it helps Catholic Charities. I mean, it helps us to even saying that I'm president of Catholic Charities lifts up our organization in a way that I'd like to have happen. So, and he's happy to do that as well. So, yeah, so it's been more of that, not so much about, issues or concerns or more just very positive. It's going fine. It's going fine.
So you will be testifying then in public on his behalf?
And I'm not sure what that testimony is, except it's a character reference. So, again, I would not have any legal background to speak at all about legal issues, but I can talk about, we're talking about right now, his integrity, his honesty, his goodness, a wonderful husband, really good husband, a really good father, a wonderful, guy in the community. I mean, one of the women from Blessed Sacrament described him as a carpool dad. He was one of our carpool dads. He drove the kids a couple days a week, whatever. He's the guy next door, happens to be, now chosen to be possible Supreme Court justice, but he's really the guy next door. That's what he comes across as, not a highfalutin lawyer or judge, but as a regular human being who could be your next door neighbor.
So he's come here to Catholic Charities here in Washington, D.C. since the nomination to serve meals to the poor with Secret Service?
Oh, yes. Yeah, they've been here. In fact, the last time he was here, we have a thing called summer service or service in summer. And the Secret Service guys all put those little badges on, saying that they were part of our program. It was kind of funny.
Did they blend in?
Well, they didn't really blend in that well. But, they did. But, people say, well, who are those guys? What are they here for? Because they are usually packing some type of protection with them. But they say come up with the black limousine or the black SUV, and they're here a bit earlier. But it's just it's an interesting story. So I said to Brett the first time he came, this was like 3 days after the nomination, it was a lot of excitement, and I said, I'm going to do a prayer. Brett, can I introduce you to the crowd? Just say who's here today to serve food. I said no. He said afterwards, if you want me to introduce a couple people, fine, but this is not about me, it's about them. It's about the people who are hungry, and I just want to be blend in as all the other people are trying to serve food. So what happens here is that right outside our building we're sitting right now, on Wednesday nights we have what's called St. Maria's Meals. It's just a regular thing we do. The homeless in this city don't get many good meals. These are really good meals. Last night they had chicken, they had potatoes, they had green beans, they actually had some ice cream bars left over. So they had a really good dinner last night. I mean, a dinner that we would all be happy to eat. One of the problems is there's no real place to eat it because we don't have a lot of tables. We do it occasionally, but we don't have tables. So they're eating with those. They've got their little cafeteria plates, and they're eating, frankly, up and down the street here. And they're pretty good about cleaning those up afterwards. But they had a good meal. So Brett's been part of that, as I say, maybe 10, 12 times before the nomination and 2 times since. And each time calls, can I come tonight? I'd like to come. It's a little bit more kind of spur of the moment now than it was before. It used to be, I'm coming. I'll be with the John Carroll Society, which is a group of lawyers in town. I'm coming, he would say, but now he just says, okay, to come tonight. Will you be there? Yeah, I'll be there. So I'm going to try to come. So it's great.
Have you two ever discussed, or has he ever grappled with, morality and the law and the Constitution?
We haven't so much discussed that, to be honest with you. We just haven't. But my belief is that it's part of who he is. I mean, this is a moral guy who is going to try to bring, good judgment, good decisions, good, I guess, Judeo-Christian values that he has into his life. So I would think he's a God-believing individual, and we haven't discussed it, but I think he sees himself as a good person who's to live by values, and he's going to be happy to share those values as best he can.
How does, I don't know if he's ever discussed this, but reconciling, that Judeo-Christian values with the Constitution, which sometimes they might not line up.
Well, the Constitution's going to be first for him, I think, because he sees that as his role. His role is to defend the Constitution. I mean, he said that clearly at his speech, when he gave the speech at the White House. My job is to interpret the Constitution as best I possibly can. Now, as a moral person, as a man of God, that's going to be a part of it. But I think he sees he's got a role to play, and the role is to basically, it's a justice in the Supreme Court. If he's chosen, I think he believes his job is to follow the Constitution and to interpret it as best he can as a judge.
Do you think you'll still see him here on Wednesday nights if he becomes a Supreme Court justice?
He said yes. We talked about it. He says, I want to. I asked him, so I said, I want to come, keep calm if I can. So we keep coaching. He said, no, that may not be possible. And he coaches his daughter's basketball team, very good coach. He was undefeated this year, and in his sixth grade basketball, and he won the state championship in that particular level of girls. But I don't. He did say, I'm not sure I can keep doing that. So,
Father John Ensler, thank you.
Welcome.
Last, we want you to hear arguments for and against Judge Kavanaugh. Joining us from Connecticut is Yale Law School professor Akhil Amar and author of this op-ed, A Liberal Case for Brett Kavanaugh. Professor, you've voted for Democrats and you supported President Obama's pick for the court, Merrick Garland. Why support Brett Kavanaugh?
Because my side lost the election, and that has consequences. I supported Hillary Clinton. She's not president. Nor did my party prevail in the contest to control the Senate of the United States. Brett Kavanaugh is, in my view, the single best person I know who could plausibly be nominated by this president, or indeed any Republican president, and confirmed by a Republican-controlled Senate. So if I had my absolute first choice in the world, if I were czar, I could think of maybe some other people that I would also love to see on the court. But if Brett Kavanaugh were defeated, I hope he won't be, I think we're going to get someone who would not be nearly as good.
You write in your piece that with the exception of the current justices and Judge Garland, it is hard to name anyone with judicial credentials as strong as those of Judge Kavanaugh. What are those credentials?
The most important thing to understand about the Supreme Court is that it's a constitutional court in effect. It hears all sorts of cases, and some of them, many of them, do not involve the Constitution, but a very significant proportion of its docket involves constitutional cases. That's not true for most other judges. They get very few constitutional cases, and so they don't have very much practice thinking about constitutional law. Brett Kavanaugh has been on a very distinguished federal court, the United States Court of Appeals for the D.C. Circuit. It sits in Washington, D.C., and he's gotten a steadier diet of constitutional law cases than most other judges, and I think he's done a very good job handling the constitutional cases that he has confronted. And by very good job, one of the things I mean is that he has thought more, I think, about the Constitution, its text, its history, its structure, than almost anyone else that I know on the federal judiciary. And the other ones that I would rank very highly, again, are folks who wouldn't be nominated by a Republican president and confirmable by a Republican Senate.
And you wrote, a good appellate judge faithfully follows the Supreme Court. Great ones influence and help steer it. In your opinion, how has Judge Kavanaugh done that?
Well, let's take a couple of issues where he has been involved. In D.C., that's where the administrative agencies are. That's where the federal government is headquartered. So a lot of the cases that are going to come up in the D.C. Circuit involve the structure of the executive branch, the structure of government. In one case called the PCAOB case, he wrote an opinion, and he didn't prevail, actually, in the D.C. Circuit, but it was an opinion that explained how the president needed to be able to have certain control over the bureaucrats in the administrative agency because the language of this document, the Constitution, vests certain powers in a president. And he took that seriously. The case eventually went up to the United States Supreme Court, and per Chief Justice Roberts, the Supreme Court sided with Judge Kavanaugh. In another area, this one involving the rights of criminal defendants, he thought criminal defendants actually weren't quite getting a fair shake, and he wrote that in cases involving civil forfeiture, the government trying to go after the assets of criminal defendants. He didn't think that was quite kosher. And once again, he wrote an opinion below, and the Supreme Court followed that opinion, this time in an opinion written by Stephen Breyer, for whom I clerked, generally considered a liberal justice. John Roberts is generally considered a more conservative justice. So here are two cases involving very different issues, constitutional issues, one more of a rights question, one more of a structure of government question, and both times Brett Kavanaugh, on a lower court, is actually writing an opinion and setting forth ideas that the Supreme Court will later follow. Now, this is particularly important because if confirmed, he's going to be on the Supreme Court itself, and he won't be obliged to always follow what the Supreme Court has said. Supreme Court justices are allowed to propose changes to precedent. Lower court judges aren't supposed to do that. So it's very important to see that he has the ability actually to persuade other members of the court, and he's done that even as a lower court judge. He has the ability to see issues of first impression where the Supreme Court cases aren't so clear one way or another and sensibly resolve them. So those are two areas where Judge Kavanaugh has shown real judicial leadership as measured by, in effect, the Supreme Court itself following his lead.
As a liberal, are there any issues that you're concerned Judge Kavanaugh, a conservative, could impact?
Sure. But again, the question is compared to what? And on some issues, I actually will take my chances with Brett Kavanaugh over other judges that could be possible nominees, because I think Brett Kavanaugh has thought about the Constitution more carefully than most other lower court judges. It's very impressive because their job description day in and day out typically doesn't involve constitutional law, so it's hard to actually study the Constitution in great detail. I think he has done that. And on various issues, I actually think because the Constitution is not an invariably conservative document, it often is stands for all sorts of very important liberal principles. If you study the document, actually, and you're really a constitutional expert, you're prepared to think about the document, I think actually as a liberal we'll do better with him than with others who haven't thought as deeply about the Constitution. I like what he has written also off the bench about the Constitution, where he's talked about the importance of the Reconstruction Amendments, for example. That's something not all conservative judges really understand, how important the transformation of the Constitution really was after the Civil War, ending slavery, promising equal civil and political rights for African Americans and others. And I think Brett Kavanaugh understands those themes better than many other conservatives.
On what issues, specific issues, would you take the risk?
Well, when you appoint a justice, you're appointing a justice who's got life tenure. They're going to be on a court for a long time, and you can't even foresee necessarily all the issues that might arise. So what you really are looking for is someone who actually shows a real understanding of the Constitution itself. Let me just give you an example. Judge Kavanaugh clerked for Justice Kennedy. Now, Justice Kennedy is a Republican. He was appointed by a Republican president, Ronald Reagan, and yet in one of the biggest cases of his career, he sided with 4 Democrat appointees on the same-sex marriage case, the Obergefell case. Let's take John Roberts. John Roberts was a Republican, confirmed by a Republican Senate, nominated by a Republican president. In the biggest case of his life, the Obamacare case, he provided the 5th vote to uphold Obamacare, joining again 4 Democratic appointees to the Supreme Court. So what you really are looking for, because you can't predict the issues that are going to arise 15 years from now. It's very hard to do. Who would have predicted that 3 judges appointed by Richard Nixon, Harry Blackmun, for whom my brother clerked, Warren Burger, the Chief Justice, and Lewis Powell, would all rule against Richard Nixon, famously in the Nixon tapes case? Robert Jackson was an Attorney General of the United States under Franklin Roosevelt, a Democrat, a staunch Democrat. He ruled against Harry Truman in a famous case involving a seizure of steel mills, the Youngstown steel seizure case. And one of the things I admire about Brett Kavanaugh is he has, in a speech that he gave, he has said that Robert Jackson is a role model for him. And Robert Jackson, like Brett Kavanaugh, worked in the executive branch, knows the executive branch very well, but also, when it actually came down to it in a very important case, was willing to rule against the executive branch. And indeed, the executive branch controlled by his own party, that's very famous. It's the Youngstown steel seizure case. And Brett Kavanaugh, in his writings off the bench, in a piece in the Marquette alumni magazine, actually celebrated Robert Jackson and held him up as a role model. I think that's actually a good choice of role model. He's not the only one that Brett Kavanaugh has, but I think that was a particularly good one.
You've followed Judge Kavanaugh's career, but you also had him in the classroom. You were one of his professors at Yale. What was he like as a student?
I had him very, very briefly because it is what we call shopping period at Yale. And I think his schedule required him to switch out of the class. So my real understandings of Brett Kavanaugh are much more as a law professor. I've watched his career as a judge. I actually read his opinions. I've taught them in the classroom. And I don't do that for any other federal judge, lower federal court judge. I usually teach Supreme Court cases, but Brett Kavanaugh has written particularly distinguished appellate opinions that I've brought to my students' attention. Over the years, I've been lucky enough to have really brilliant students. They go on to clerk for all sorts of judges, Merrick Garland and Brett Kavanaugh. And whenever they clerk for Merrick Garland, they say, wow, they tell me afterward, not during the clerkship, because I don't try to ask them anything while they're working for someone else, but afterwards, well, what was the experience like? And they tell me amazing things about Merrick Garland, and they tell me really great things about Brett Kavanaugh. One thing that your audience may not know is that when Merrick Garland was nominated, Brett Kavanaugh, Merrick is a Democrat, Brett is a Republican, Brett Kavanaugh said very nice things publicly about Merrick Garland. He complimented Merrick Garland as a superb judge. Good for him. And to repeat, I actually had one student who was supposed to clerk for Merrick Garland. Then he got nominated by President Obama, so he had to take a temporary leave of absence, in effect, from the D.C. Circuit while he was getting ready for a possible confirmation process. So this person who was going to clerk for Merrick Garland was temporarily out of a job, and who steps up? Brett Kavanaugh says, "I'd be happy to have you work with me." Good for him.
Why his decisions? Why do you teach his decisions? What is it about his approach? And what do you think of his writing style as a judge?
I think it's very thoughtful, soft. He doesn't overstate things. He addresses counter arguments. I'll give your audience a couple of things that they can actually look at off the internet and see for themselves. Some writings that he wrote more for the general public rather than judicial opinions, which are often written for lawyers and other judges and legal experts. But one thing that shines through Brett Kavanaugh's writing, both on the bench and off, is his real respect for the text, the history, and the structure of the Constitution. I'm holding up a copy of the Constitution. He is an originalist, and originalists are jurists. Some of us are liberals. I'm an originalist. Some are conservatives who pay particular attention to the words and the background history of the Constitution. The Warren Court was a famously liberal court. Its driving intellectual force was Justice Hugo Black, a former senator who always carried a copy of the Constitution around with him. And Hugo Black is a crusading liberal originalist, and he was the driving intellectual force behind the Warren Court. So there are liberal originalists and there are conservative originalists. Not all jurists are originalists. Some emphasize precedent more than the text, history, and structure of the Constitution. Others emphasize practical consequences and policy considerations more than the text of the Constitution. I teach Brett Kavanaugh's opinions because I teach constitutional law. For me, constitutional law begins with the Constitution itself, and more than just about any other lower federal court I know, Brett Kavanaugh's opinions have actually tried to elaborate the Constitution itself in sustained ways. Now, for your audience, because some of the cases that he's written are kind of technical cases about the structure of administrative agencies, I can recommend two pieces. Let me just take a look here that they can get off the internet, and one is a talk that he gave at Notre Dame Law School on the judge as umpire. So if you just Google that, you'll quickly be able to find a hyperlink to Brett Kavanaugh, a talk on the judge as umpire, and it's a very thoughtful discussion for law students, so it's not aimed too high, about Brett Kavanaugh's own understanding of the judicial role. And I think his voice comes through, and I see the voice of someone very, very much like actually Anthony Kennedy in certain ways. There's an honesty and an earnestness. He's more of an originalist than Justice Kennedy. He pays a little more attention, I think, to the text of the Constitution, because he comes in a generation where conservatives in general are more focused on the text of the Constitution than was the case a generation ago. Another piece that I think your audience might find of interest is one in which he actually, it was this Constitution Day speech in September of 2017, so basically just about a year ago, September 17th, 2017, on the enduring significance of the text of the Constitution. So again, if your audience just Googles Brett Kavanaugh enduring text of the Constitution, they'll pull that up, and you can see Brett Kavanaugh yourself. Your audience can. You can hear his own voice, and he'll probably do a better job of explaining himself than I could do.
Well, finally, Professor, have you heard from Judge Kavanaugh since you wrote that piece, making the case for him?
He's a very polite person, and he's sent me a couple of very quick thank you emails, and I know he's very busy, so I did appreciate that he just took the time just to say thanks. But he didn't know that op-ed was coming at all, and if someone else had been nominated, I wrote that op-ed. I was asked by the New York Times to write something in the event he was nominated. I spent several weeks, actually, before that, really looking at other people, all the people on President Trump's so-called short list. And I came to the conclusion that I thought, no disrespect to the others, that Brett Kavanaugh was the best. And I sort of wrote up my reasons for that in that op-ed, which is why it was ready to go when the nomination occurred, because it had been written in the days before the nomination. After I tried to carefully read Judge Kavanaugh's opinions and some of the writing and off-the-bench works and some of the writings of some of the other people on President Trump's shortlist. And again, no disrespect to them, but I think the president picked the best person for the job, given that he was going to pick, frankly, a conservative Republican.
Professor Akhil Amar, thank you. Ron Klain, you've written 2 columns for the Washington Post opposing Judge Brett Kavanaugh to the Supreme Court. Why?
Well, look, I think first one of them was about the fact that there are hundreds of thousands of pages of documents that Judge Kavanaugh, as a senior White House aide, wrote that the Senate Judiciary Committee hasn't seen. He'll be the first nominee ever in modern times to have a record like that the committee hasn't seen. And so I think it's very important for the senators who are exercising their constitutional responsibility of advice and consent to know what Judge Kavanaugh wrote, what he said about important issues that he may pass on. I think it's very important for them to know it for the obvious reason they should have a full a set of information, but for 2 other reasons. First of all, the people who picked Judge Kavanaugh may well know what's in those documents. He wrote those documents as a senior aide to President Bush. A lot of Republicans who worked in the White House in the Bush years saw those documents. They may well have passed that information along to the Trump administration or the outside groups helping President Trump. So it's asymmetric, that his supporters know what's in those documents. Those who are looking at his nomination more critically don't. That's the first reason. Secondly,
those documents will eventually come out. The Bush Library isn't releasing them now. The Senate Judiciary Committee isn't getting them now. But under the Presidential Records Act, those documents will start to come out in 2019, 2020. And it would be a mistake to vote on his confirmation now and then later have this information come out and it'd be too late to really influence the record. So I think there's a process issue here. The documents should come out. The Senate should have a full record.
Before you get to the second column, though, do you put anything off the table? Because the amount of documents is voluminous. I mean, hundreds of thousands.
Yeah.
Anything off the table that doesn't need to be looked at?
Well, look, I think that to the extent there are some documents that are either national security matters or legitimate claims of presidential privilege, of course those documents should be withheld as need be. They just haven't even tried to get most of the documents. More than half the documents haven't even been requested by the majority on the Judiciary Committee. So we're not talking about what's off the table. There's just a lot of things that haven't been brought to the table at all to be discussed. When Elena Kagan was nominated to the Supreme Court, she had similar positions in the Clinton administration to what Kavanaugh had in the Bush administration. 99% of those documents were not only produced to the Judiciary Committee, but actually put on a website. Any American who wanted to could go read those documents. So there's a big process issue about this. And as I said, it's an issue that ultimately will come home to roost because those documents will ultimately, because of the Presidential Records Act, become public. If Brett Kavanaugh is confirmed, he'll be on the Supreme Court. We'll find out what his record was after the fact. That's not the way to do this. I don't think that's in anyone's interest. I don't even think that really that's in Judge Kavanaugh's interest. So I think that's a very, very important issue about what's happening right now in the confirmation process. When you get to the final merits, look, the seat Judge Kavanaugh has been nominated for is the swing seat on the Supreme Court, Justice Kennedy's seat. Way back in 1987 was the last time this seat was vacant, when Justice Lewis Powell retired from the Supreme Court in 1987. President Reagan nominated Robert Bork for that seat, a very, very conservative justice. Democrats and Republicans in the Senate came together, rejected Judge Bork's nomination. President Reagan then, a very conservative president nonetheless, nominated a more moderate person to be that swing vote, Anthony Kennedy. And I think we're kind of seeing history repeat itself in that regard, which is Judge Kavanaugh, who is a very well-qualified, very distinguished judge. I take nothing away from Judge Kavanaugh in terms of that regard. He's a well-liked member of the D.C. Circuit and certainly has every kind of academic and professional credential for the job. But he is very, very conservative. And I think that conservatism is out of step with where the middle of the Supreme Court should be and where the middle of our country is. And so I think a judge who more reflected that, who's more in the Justice Kennedy mode, would be a more appropriate replacement for Justice Kennedy.
You wrote in one of your columns that reversing Roe v. Wade will be just the beginning if Judge Kavanaugh is confirmed as the next Supreme Court justice. Explain why you believe this.
Yeah, so there's a lot of focus on whether or not Brett Kavanaugh, if he's confirmed to the Supreme Court, would be a vote to reverse Roe versus Wade, the landmark case that upheld a woman's right to choose to terminate her pregnancy. And that's been the focus, and a lot of discussion about whether or not Roe will be reversed or not. Now, reversing Roe means that there'd be no federal constitutional protection of a woman's right to choose. It would really be up to the states to decide. Some states might ban abortion. Some states might allow abortion. Some states might regulate abortion very heavily. Be a range of things. And I think, in some sense, that may give some people a false sense of security as to what would happen. Maybe I live in a state where I think abortion will be legal. Maybe, some of these larger, more progressive states, abortion will be legal. So what do I really have at stake in that? The point I was making in that column is the issue won't stop there. The folks who oppose Roe aren't really making a federalism argument. Oh, let the states decide. They're saying ban abortion. We need to stop all abortions. And I suggest in that column that what will happen next is that advocates will come to the Supreme Court and say, hey, a fetus is a life under the 14th Amendment, and not only isn't there a federal constitutional right to get an abortion, there actually should be a federal constitutional prohibition against abortion. The Constitution should require that a woman be banned from terminating her pregnancy without some kind of due process of law for the fetus. And in fact, this isn't a hypothetical position. This isn't like some scare tactic I've invented. This is what legislators in Iowa argued in the floor of the Iowa legislature when they tried to ban abortion there last year. They said, oh, we think the Constitution of the United States protects fetuses' rights. Abortion should be illegal under the Constitution. It's what conservative legal scholars have argued in legal journals. So that's the argument that I think that's coming next if Roe's reversed.
Well, why do you believe, though, that Judge Kavanaugh would reverse Roe v. Wade when he has said in earlier confirmation hearings that that is legal precedent that he would respect?
Well, he said it's settled law, and I think that's a phrase that has a lot of ambiguity to it. Let's talk about what else he has said. In the Garza decision that he wrote as a dissent that he wrote as a member of the D.C. Circuit, when he said he would have voted to deny the right of a 17-year-old immigrant to get an abortion when she was held in detention in the United States, he referred to her request as a request for abortion on demand. That's the phrase he used in his opinion. Now, abortion on demand isn't a legal phrase. It isn't in Roe v. Wade. It's a political phrase. It's a phrase that the anti-choice movement uses to describe a woman seeking her constitutional rights. I think that's a very loaded phrase that tells us a little bit about where Judge Kavanaugh is. He also said in that same opinion, when he referred to Roe versus Wade, he referred to it as an existing Supreme Court precedent. Well, that's not a very reassuring view of what a Supreme Court precedent is. And indeed, I said to someone the other day, if my wife referred to me as her existing husband, I'd be checking the state of our life insurance policy. So I think to say that something is just an existing precedent doesn't really show that he really believes it's settled law. I think it's easy for nominees to come before the committee and say things are precedents. Last year, Judge Gorsuch came before the Senate Judiciary Committee and said, oh, I have a great respect for precedent, and precedent's the anchor of our law. And a year later, in the most recent term of the Supreme Court, he voted to overrule a 40-year-old unanimous precedent of the Supreme Court, the Abood decision in the Janus case. And so, I think...
Labor issues.
Labor issues. So I think vague assurances about precedent, vague assurances about settled law really don't prove much of anything. I think if you look at Judge Kavanaugh's writings, they show a certain hostility towards abortion and a certain ambiguity about the status of Roe as an existing Supreme Court precedent.
How are Judge Kavanaugh's writings different from retired Justice Anthony Kennedy, who he would potentially replace?
Yeah, so, we see in Justice Kennedy is a view of what we might call a living constitution, a view that there are substantial unenumerated constitutional rights. Justice Kennedy used the phrase dignity. It's kind of one of the key phrases in his jurisprudence to define that. And as a result, was consistently a vote to uphold Roe and uphold the basic concepts of Roe. Yes, the court cut the scope of Roe's protections back over the years with other decisions, with the undue burden test and things like that. But I think we see in Justice Kennedy a view of a constitution that protects individual rights, that protects these kinds of what lawyers call unenumerated rights, these personal liberty rights that aren't necessarily spelled out in detail in the Constitution. You don't really see that in Judge Kavanaugh's decisions. You see a jurisprudence that's more of the Justice Scalia mode, and in fact that's what President Trump said when he introduced Judge Kavanaugh to the country. He was a judge in the Scalia mold. And indeed, Judge Kavanaugh himself has said in speeches one of his judicial heroes was Justice Rehnquist, who was one of the dissenters in Roe versus Wade. And he cited the fact that Justice Rehnquist was a dissenter in Roe versus Wade as an act of judicial heroism or courage or whatever phrase Judge Kavanaugh used specifically. So, I think, those are kinds of his role models. It's kind of where he fits on the court's jurisprudential spectrum. And I think that's the kind of justice he would be.
What motivates you to speak out against his nomination?
Well, look, I have spent a lot of years working on Supreme Court nominations as chief counsel of the Senate Judiciary Committee back in the 1980s, as a White House aide to President Clinton who worked on judicial selection in the 1990s and as a White House aide to President Obama, who worked on judicial selection in the early years of President Obama's administration. So it's an issue that's been a great concern to me. And as I said earlier, it's not motivated by any animus against Judge Kavanaugh. I know him personally a little bit. I like him. I think he's a very nice guy. I think the things that have been written about him as a good person, as a good employer of law clerks, all these things I think are true and absolutely so. And I, as I say, I'm a bit of a fan of Judge Kavanaugh's in that respect. But I think that this isn't personal. This isn't really about him. This is really about the balance of the Supreme Court. This seat that for more than 30 years has been the fulcrum in determining our constitutional rights and determining the scope and outcomes of these key constitutional decisions. That was first held by Lewis Powell, who was kind of a moderate, a Democrat appointed to the Supreme Court by Richard Nixon. Someone who really set the balancing place on the court in one generation, and then Justice Kennedy, who did the same for the past 30 years. And I really think someone in that mode is the right person to fill this seat.
What or who were you in, which judicial selections of President Obama were you involved in?
I worked both on the Sotomayor and the Kagan nomination in 2009 and 2010. And then earlier in the Clinton years, I was very involved in President Clinton's selection of Justice Ginsburg, and then ultimately the efforts to confirm Justice Breyer.
Did you support President Obama's pick to replace the late Justice Antonin Scalia when he chose Merrick Garland, a colleague of Judge Kavanaugh's on the 10th Circuit? I did. I was not in the government at that time, so I was just an outside advisor, but certainly helped the Obama administration try to get a hearing for Judge Garland and try to get Judge Garland confirmed. I think it would have been a great pick for the Supreme Court. I think he's obviously a very distinguished judge. He's the chief judge of the court that Judge Kavanaugh sits on, the D.C. Circuit Court of Appeals. Very distinguished career as a federal prosecutor, as a senior official in the Justice Department, and I think merited full consideration by the Senate. For Democrats, the repudiation of Merrick Garland still stings, and some say that is why Democrats should try to hold up Judge Kavanaugh's nomination. How much of a factor is that for you?
It's not for me. I mean, I don't think this is a question of tit for tat or revenge or anything like that. I think that obviously what happened to Judge Garland was unfair and shouldn't have happened, and was a wrong of historic import. But I think Judge Kavanaugh deserves to be considered on his own merits. And again, I think, as I said before, it's not a question of professional qualifications or character or anything like that. I think it's a question of finding the right balance. We're a very divided country. We're narrowly at the margin of Republicans and Democrats. The last presidential election was extremely close. The Senate is extremely divided. And to tilt the Supreme Court very far to the right at a time when the country is really balanced between left and right, Republicans and Democrats, I think throws that institution out of tilt. And I think that's really the central issue here in the Kavanaugh confirmation.
Beyond Roe versus Wade of the abortion issue, where else do you have concern about legal precedent when it comes to Judge Kavanaugh?
So I think his views on executive power are also quite broad and also very, very far in one direction. Judge Kavanaugh wrote in a law review article in 2006 in the University of Minnesota Law Review that presidents should be free from having to answer questions in investigations. Presidents really shouldn't be constrained and burdened by having to be investigated. And look, I think even leaving aside the current issues around President Trump and the obvious points that makes, that perhaps President Trump selected Judge Kavanaugh because he thought he would be favorable to him on these issues about the Mueller investigation and other investigations the president's facing. Even leaving that aside, just as a general statement of executive power, it's a very, very broad statement and a very unbalanced statement about our system of checks and balances. And so I think that's another area of concern with Judge Kavanaugh. He's also taken a view about kind of executive power as it potentially relates to the health care law, the Affordable Care Act. And I think that's, again, an issue that will come up in the confirmation hearings and is another issue of concern.
Akhil Amar is a self-described liberal who said he supports the nomination of Judge Brett Kavanaugh because of him being an originalist, a jurist, and a deep scholar of the Constitution, that he has studied it. Why isn't that enough for you?
Well, look, I don't dispute that Judge Kavanaugh is an originalist and a scholar and a student of the Constitution, and a very able student of the Constitution. But we're not picking a law school dean. We're not picking a constitutional poobah. We're picking someone who will hold the seat, that will be the balance on the scope of all of our individual rights. A woman's right to choose, our right to live in a society with a constrained president, our right to enjoy free speech, all these rights. And so I don't think it's unfair. I don't think it's wrong. Indeed, I think it is the Senate's constitutional duty to consider that and consider what shape and direction the court should take as an institution, how that impacts our rights. And the general statements that Professor Amar, who I admire greatly, made about Judge Kavanaugh don't really go to that. They basically say he's a qualified individual, he's a distinguished individual, all true. But our rights hang in the balance in this nomination. And Brett Kavanaugh's resume alone isn't enough to merit a yes vote when our rights hang in the balance.
Ron Klain, finally, if not Judge Kavanaugh, then what conservative would you say should replace Justice Kennedy?
Well, what I know for sure is if I endorse a conservative on TV, President Trump will never, ever, ever nominate that person. And so, it's not my place, and I'm the wrong person to ask who Donald Trump should nominate to the Supreme Court. But I do think, as President Reagan did after Judge Bork was defeated, it's possible even for a very conservative president to find a middle ground and to find a nominee who will be acceptable to that president, as Justice Kennedy was, but acceptable to a broader array of the American people, a broader array of the Senate, be able to get Democratic votes. We are not stuck in an inevitable confirmation war. It's worth remembering that after the very divisive Bork nomination, Justice Kennedy's nomination was confirmed unanimously by the U.S. Senate. And so I think it's possible to get past this divisiveness with a consensus nominee, and that is really what the president should bring forward.
Ron Klain, thank you for the conversation.
Thank you so much.
You can also watch all of these events with Judge Brett Kavanaugh if you go to our website, cspan.org. That's also where you'll find information about the multi-day confirmation hearings coming up. We'll have gavel-to-gavel coverage, of course, of them. Go to cspan.org for more details.